Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth. Court of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for all 5 cases that we will be hearing today are Justice Mary Sullivan and Justice Vicki Henry. We will be hearing all 5 of the cases on the hearing list today using our Zoom virtual argument video conference platform as an accommodation to safety needs caused by the recent surge in COVID infections here in Massachusetts. As a preface to the arguments today, I just want to remind everyone watching that we do have our notes typically off to the side, and if we are not facing the camera on our laptops at all times, it's because we have need to consult our other supporting materials and not because of any inattention to the very important cases that we have to hear today. The first of those cases, the first 3 cases will be criminal matters, and the first of those is the first case on our list for hearing, case number 2020 P708, the Commonwealth versus Troy Rakeem Stewart. Mr. Sukecki.
Good morning, Your Honors. This is a case where the Commonwealth just didn't have much evidence to prove their case. In this instance, the alleged rape against my client occurred when he was 17 years old. At the time of trial, he was 28 years old. It's the complainant said during the trial that she had never spoken to Mr. Stewart about the incidents and never complained about it. And he years later had her target work. She confessed or told the person at Target that she had been molested by her uncle when she was a child. In this particular case, the actual evidence in the actual rapes, the evidence came, it was a he said, she said. And she said that he had come to her apartment, she had buzzed him into her apartment, and without words being exchanged, in the first instance, there was a sexual intercourse, but there were no words exchanged, and he left. And 2 weeks later, he came by, again, texted her. She answered the text, opened the door, allowed him into her apartment, and this time he let her down the hall, and she, without words being exchanged, performed oral sex on him. And then years later, this comes out. The overriding infection to this case had to do with bad acts. And the Commonwealth filed a motion in limine in order to contextualize and improve on one level constructive force in this case, and to essentially explain the lack of communication during the rape. And the Commonwealth, the judge allowed the motion in limine to allow certain bad acts. And these bad acts occurred when both of these individuals were children. The complainant was 9 to 11 years old, and my client was 11 to 14 years old when these incidents occurred. And these bad acts infected the trial, and they were used as propensity evidence. And those.
Well, you know, I understand that that's your argument. The judge gave very detailed and targeted instructions limiting the use. And I'm always reminded in this context of an exchange that I didn't hear personally, but I was described to me between 2 of my former colleagues, Justice Flannery and Justice Cass. Justice Flannery, as I understand things, walked into Justice Cass's office and said, "Explain to me again, what's the difference between pattern and propensity?" I understand that it's a subtle distinction, but we do allow prior bad acts for state of mind, for motive, for for nature of the relationship, and for pattern or method of operation. In this instance, the judge provided very specific instructions, and as the relationship between these two and the power dynamic developed, the judge made the discretionary judgment that it was appropriate and, in fact, important to provide that context to understand the nature of, as you put it, the wordless acts that occurred that formed the subject of the prosecution.
And I understand that, Your Honor, and the defense counsel agreed to some level that for contextual purposes, that would be okay. But in this particular instance, they didn't stick to just this summary. And there's a case that's cited in my brief where when you do the bad act evidence, and especially when there's a prior instance, and this is the same conduct he's alleged to have done when he was a child, it should have been done in a summary fashion. And in the first instance, if you read through the transcript, the prosecutor does in fact do a summary, essential summary of what had occurred. And he said essentially, she said that he was mean when she was a kid, and that he had violated her vaginally and orally during that time. That should have been enough. But the difference here is the prosecutor, because there was no other evidence to speak of, exclusively used the bad act evidence over and over again. And then the detail with which the alleged rapes that occurred when they were children. He's 11 to 14 years old, and she's 9 to 11. And she got to describe in detail how he did it, how it hurt. She asked how she felt, all these emotional feelings. And what happens in a case like this, where there's bad act evidence, especially when it's involving a child who's 9 years old, and she likes to say it, he's 9 years old, and she exploits the fact that he's her uncle, but there's a 2 or 3 year age difference. So it's not like a power play by age.
Well, yes, I mean, he was several years older and in a family dynamic, in a hierarchically superior position. At least a rational jury could understand it that way. I think that the propensity argument would be more forceful if the acts were against different individuals. Here, it was it provided an understanding of the relationship between these two, and how he had exerted force over her for really a very long period of time. At least that's the argument.
Well, I would concede that for that one context, that and I don't think they should have been allowed to use it as constructive force, because they're children again. But
I'm not sure they are children, but they are children. I mean, in some respects, the age difference is more significant when between a 14 and 11-year-old than it is between a 24 and 21-year-old.
But in the same instance, the assaultive behavior of using bald socks or pushing her or being mean to her doesn't mean as much as an adult. And what it does is, as an adult is, and what's infecting this case is the juror's sympathy and empathy for the 9-year-old. And in fact, the Commonwealth specifically leads her oral argument with the 9-year-old sympathy play, because that's all they had. But it's one thing to allow.
They have a little more than that. Don't
Well,
they?
they had her word. I mean, but
have
in essence,
testimony.
there's not much to say except that she didn't say anything, and this is the narrative of what happened.
Right. So
But
let's talk about that for a second. I understand your argument to be a Dwyer argument, which is that the detail was overwhelming and prejudicial. But was the detail within the judge's discretion in order to explain her silence over the years and at the time of the acts for which he was indicted?
Yes, but it's an abuse of discretion. And there's a case cited in my brief where it doesn't mean the judge was bad or wrong or in this particular instance. And I think it had to do because of the age also. What
is your best case? You've referred to the case cited in your brief. Is that Dwyer that you're
as far as limiting as far as summary disposition? I mean, he has to describe it in summary fashion. And if you go into the detail, it just becomes the case because the Commonwealth uses it, and that's what they have. And I understand that's why they did it. But when you lead your oral argument with that she was 9 years old and he had this over her, and you also have to keep in context of the individuals in the courtroom.
Counsel, can I ask if they had admitted the fact of the acts without the detail, the prosecutor still would have been able to lead with that, right?
Yes, but I would suggest the way the prosecutor used it in her oral argument was deliberately designed to play on the sympathy of jurors. And
that's a different argument.
Yeah, that's a closing argument concern. Justice Sullivan has put her finger on the difficulty I'm having understanding, because if you concede that the behavior in summary fashion could have been admitted, then there's no reason independently why it couldn't be the jumping off point for the prosecutor's closing.
I don't object to the fact that it was her jumping off point, but if you read through it, that's the closing argument, but it was a deliberate play on the age, because she was when you're 17 and 15, it's different. And if all they had without the prior bad acts coming in, it would be a situation where it's pretty inexplicable to have that kind of.
But again, isn't that the point? The point is that they had already established. That the defendant already had established a power dynamic that placed him in a superior position of control, and her in a position of submission or acquiescence, which places into context the circumstances of the charged offense.
And as Dwyer says, it's the summation part, and it's the over and above, and it's throughout the trial. It's being used as, and it's the only way she has to really push this case, is that the 9 and you can't lose sight of the fact also that they are children when this stuff happened, and then
Counsel?
bald socks is in a knife.
Well,
that
counsel, the defense counsel didn't object to the non-sexual assaults at trial. What I'd like to concentrate on is, because I'm not insensitive to your point about the detail, and I've read the cases and I understand from whence you derive that, and it's a legitimate point. But what is the incremental harm in this case of the detail when it's undisputed that the fact of the sexual assault between the 9 and the 11-year-old are going to come in? How do you get to reversible error? Even if we agreed with you that the details should not have come in, how do you get to reversible error?
Because even if you walk away from this case having no other context, if you just read through the case, what you walk away is this 9-year-old and the dynamic that happened when they were children. It in fact, the details, the literal details that were used over and over again, even exploiting the fact that the uncle-niece dynamic was used in order to prove the case. And that's the emotion part, the sympathy part. You're making the jurors make their decision based upon redressing a wrong that happened when they were children. The actual fact of the actual rape from 17 and 15 is a straight, it's just a very short set of facts. And if it come in and said, okay, he had done this, and there's a part where it stops, and then she goes into detail, and the defense counsel starts to object. It's like, okay, and he says, this is about the motion in limine, where you're asking the detail. Oh, it hurt. Oh, how do you feel? That stuff happens when she was a kid. That he was not on trial for them, and she's using that emotion to work up the jury to get her decision. And that's wrong. I mean,
so counsel, wasn't there a hung jury the first time around, and then there was this trial?
Yes, Your Honor.
So was the level of detail different?
And I knew you were going to ask that question, Your Honor, and I don't have transcripts of the first trial, so I can't answer that question. But I think so, because I think that it didn't come in the first time because they used it and it was emotional limit. Maybe perhaps ADA has an answer to that. But the one thing I do want to say and repeat, as you walk away from this case, is that it just feels wrong that to use something that happened when they were children, unindicted, even unspoken of until late in her 20s, and to bring it into trial and to just hammer it home during the trial, and the jurors obviously, you can't not feel that. I mean, anybody reading this case will say the same thing with the detail that you hear. Say, oh no, this is so wrong. But if you take it into context and take that stuff out, and it's less of infection. And if you read the closing argument is there's all kinds of errors in closing argument in terms of exploiting the propensity and even expressing a personal opinion about the psychological responses. And then she even speaks to my client's demeanor in the courtroom and saying, did he act like an innocent guy because of the way he answered questions? And that's wrong. So there's very detailed errors in the closing. And when you leave this case, just realize it feels wrong. There's too much emotion, too much infection, too much play on the sympathy every step of the way in order to get a conviction for something that didn't have a lot of except a he said, she said.
Ultimately, what you're arguing is a judgment call.
And it was an abuse of discretion.
Well, you know,
and that's I mean, it is, and that's where
you could say it was an abuse, and our challenge is to determine whether you've made that case.
I agree, Your Honor.
Okay.
So if there's no further questions, I'll rest on my brief, but there is abuse in closing argument, and I urge you flip this case and give Mr. Rakam Stewart a new trial. Thank you.
Okay. For the Commonwealth?
Good morning, Your Honors. May it please the court, ADA Megan Monahan on behalf of the Commonwealth. The defendant's convictions here should be affirmed where there was no abuse of discretion in the admission of the prior backed evidence and the prosecutor's closing argument. What is critical here, and keep in mind which came through in the theme of counsel's argument, is every case is fact specific. And this is a case, as Justice Green said, Chief Justice Green, about power dynamics and uneven power dynamics, where the defendant took advantage of his biological niece, the victim who's 3 years younger than him, such that she was scared of him and the repercussions of resisting him. The charged rapes occurred when the victim was 15 years old and the defendant was approximately 17, 18 years old, where he arrives at the family's apartment, the victim's family's apartment one morning, vaginally rapes her, and then a few weeks later, he again arrives at the apartment and orally rapes her. And for her part, she does not react, trying to stay quiet, so not to upset the defendant that she was afraid of what he may do. And she didn't tell anyone what happened because she didn't want to admit that she had been previously abused. So to understand this case, to understand why the defendant did what he did, and to understand why the victim reacted the way she did, it's essential to understand their entire relationship and the uneven power dynamics that resulted from the childhood abuse that occurred when the victim was 9 to 12 years old and the defendant was 11 to 14.
Attorney Monahan, I understand the framework of the case, but by the standards that we usually, or the comparisons, by comparison to the other cases that we typically see of this nature, what we have here seems like a lot, both in the number of prior occasions and in the level of detail, as Attorney Suchecki has detailed. How do you respond to that?
Well, I think pointing to specifically Commonwealth v. Dwyer, which is what defense relies on, in that case, there was testimony about 7 uncharged incidents versus the 2 charged incidents. Here we had very summary detail about physically assaultive behaviors, very short, high level summary, and then discussion of 2 uncharged rapes. And then even breaking it down again with Dwyer, the transcript pages. The court's concern in Dwyer was that the testimony was 21 pages about the uncharged conduct versus the 15 pages of the charged conduct. Here we have the opposite. It was 8 pages of direct testimony on the uncharged conduct and 29 pages of direct testimony about the charged conduct. And so just breaking it down by the numbers here and taking a step back, it didn't overwhelm the case. And this was well within the judge's discretion. Even during the trial, as the trial judge was sitting there over the defense's objection, being able to view the victim's testimony, see her demeanor, see the jury's reaction, the trial judge says, no, this is narrowed. This is in no way excessive. I'm going to allow it. And that is within the judge's discretion, sitting there and being able to view the parties.
Counsel, why was it necessary for there to be testimony as to how much it hurt?
In that the testimony of for the sexual assaults,
the 9 sexual assaults at the age of 9. I think the jury could draw their own conclusions on that from their own common sense. Why was it necessary to have that type of I'm not talking about numbers or quantity. Now we're talking type. Why was that type of evidence necessary, and was it an abuse of discretion to allow it?
It was an abuse of discretion, particularly here where this was a case of constructive force, and the probative value of this evidence was the victim's state of mind as one piece of the probative, but a very important piece is the victim feared the defendant. Why did she fear him? Because he had hurt her. She didn't know as a 9-year-old, she was confused, she cried, she didn't know what had happened. And this whole abuse formed the relationship and the power dynamics such that the detail was necessary in a way to explain why she didn't react or resist when she was 15 years old. And so it really goes to the Commonwealth's constructive force. And I wanted to answer Justice Henry's question about the hung jury in the first trial previously. So there were 2 trials and the testimony was admitted over motion in limine in the first trial. It was the same defense counsel and prosecutor. And in reviewing the testimony, I would say that the first trial had more detail in that it was the victim testified that the defendant had bullied her brothers, and she had said the sexual assaults occurred more times than she can count. Now, Judge Connors, during the trial, although the defendant objected, noted that he would not have allowed the testimony about the brothers because that was going over the line and too much. And Judge Cannoni, in the second trial during the motion in limine, said, okay, I don't want to hear too many times count, that's over the line. And she used her discretion to narrow it to say, we need to focus on the 2 charged conducts. And I will say that the claim that this was prejudiced or infected the trial is belied by the fact that in the first trial, this testimony was heard and they couldn't return a guilty. So that in itself demonstrates that this did not have the prejudicial effect the defense is claiming, and this was within the discretion of the trial judge, who gave very thorough limiting instructions, who was very aware of the issues and said, this has to be focused on the 2 charged conducts. I don't want to hear the sexual assaults occurred more times than she can count. So the judge, weighing the issues, understanding the probative versus prejudicial effect, limited it within her discretion, and unless palpably wrong, should be upheld. And here, where it was very probative of the constructive force, the Commonwealth would ask the court to affirm the convictions. And with respect to the closing argument of the prosecutor, it was proper in that the prosecutor relied on the evidence and reasonable inferences drawn from and used particularly the prior bad acts evidence for the ways in which it was admitted. If there are no further questions, the Commonwealth would rest on its brief.
Seeing none, I thank you both for your argument. The case is submitted.
Live and recording.
The next case on our hearing list this morning is the second of our criminal matters, case number 2021 P466, Commonwealth versus Michael S. Collins, Jr. Mr. Gravina, you may begin.
Good morning, Your Honors. Attorney Dana Gravina on behalf of Mr. Collins. Mr. Collins has raised 2 issues in his appellate brief.
Mr. Gravina, just a moment. We don't have the timer going. There we go. Okay, please begin. I'm sorry.
Mr. Collins has raised 2 issues in Collins' direct appeal. That issue involved prior bad acts, testimony and evidence, which was offered at his trial. Mr. Collins was alleged by the Commonwealth to have committed a separate shooting from this case, which occurred in Chelsea approximately 5 to 6 months before the shooting that he was on trial for. In that, we'll refer to that in the briefs as the Chelsea shooting, and I'll refer to that as the Chelsea shooting here. There was conflicting testimony as to whether or not Mr. Collins was the person who actually committed that Chelsea shooting. The
Counsel?
victim, yes,
Is that why you call that, you characterize that evidence as weak?
yes, exactly. Because the individual who was actually shot in the Chelsea shooting testified prior to an motion in limine hearing prior to trial that Mr. Collins was not. He was unequivocal in his testimony that Mr. Collins was not the person that shot him. The evidence that
There
the
was
Commonwealth,
reason to be skeptical. A rational juror could conclude of that denial, right?
well, that's certainly what the Commonwealth contended, was that there was reason to be skeptical of what he was saying. But
Because
Mr. Collins,
he previously had in fact identified Mr. Collins as a shooter.
well, that's what the Commonwealth contended. But there was no recorded statement that he ever gave to that effect. There was no photo array that he had signed. There was nothing documenting what the Commonwealth contended, which is that Mr. Arnold had identified Mr. Collins as a shooter the day after the shooting, while he was in the hospital in the intensive care unit, receiving morphine for his injuries that he sustained during the shooting. And
Right, but what there was a police officer who testified to it. There was a photo array with like an X marked on it, and he used the same nickname of the defendant as was indicated here, albeit I know you've got a contention that Laguerre said it was Goldie instead of Goody.
that's correct. But again, all of that required that the police officer's testimony be credited over that of Mr. Arnold. Mr. Arnold was adamant that he did not make that check mark, that he did not say Goldie or Goody to the police while he was in the hospital. His testimony was that the police are the ones who introduced the name Goody and the name Michael Collins to him when he appeared before the grand jury. And in fact, Mr. Collins was never charged in any way with the shooting involving Mr. Arnold, which goes to the weakness of the evidence that, in fact, Mr. Collins committed that shooting, the evidence that he committed that shooting.
Did Mr. Arnold testify to the grand jury that the defendant had committed that shooting?
My understanding is that he did not. I did not see anything indicating that he ever said that. My understanding is that he told the police when he appeared when he was scheduled to appear before the grand jury that he did not know who shot him. He didn't see the person that shot him, and that he had never heard the name Goody or the name Michael Collins, and that it was the police who were trying to get him to testify before the grand jury and identify Mr. Collins as the shooter.
But they didn't. But I mean, at least if someone credits the officer's statement, and I realize you're suggesting that the witness said that the police had fabricated this conversation out of whole cloth, but the police didn't try to get him to offer that grand jury testimony out of whole cloth. They were basing it on his statements immediately after the shooting, and then according to the police's version of events, he had a change of heart in the intervening period of time.
And
there are a lot, by the way, there are lots of reasons why a witness may recant in these circumstances.
Your Honor, what I would say is we don't know that that's what the police were basing that off of, their encouragement of him to testify to that. They claim that that's where they got the name Goody and they got the name Michael Collins, but it's contradicted by Mr. Arnold's story about what happened in the hospital. Perhaps the police got the name Michael Collins from some other avenue during their investigation into that shooting. We don't know that. It's a position that is contested by Mr. Arnold. He says,
well, yeah,
that
of course, but I mean, ultimately, these questions of whether to admit the evidence are matters committed to the discretion of the trial judge, are they not?
They are, and what our position is that when you have a situation like this, where there is not clear evidence that the defendant committed the alleged prior bad act, it's contested. I understand the standard for that the judge has to find initially is a preponderance of the evidence. Did this occur by a preponderance of the evidence? But once the judge makes that decision, the judge then has to go on to balance the relevance versus the prejudicial effect. And when the evidence is not strong, and there's a real question as to whether or not the defendant committed the prior bad act, that should be factored into the equation of whether or not the prejudice outweighs the relevance.
Well, I hope it doesn't get into too much of a bootstrap here, but we are, of course, also not viewing the testimony in isolation. There is an interrelationship between that testimony and another prong of your argument before us today, which is the ballistics report.
Correct, and they are somewhat interconnected. You've got weak evidence in terms of the testimony of who did it, and that should be taken into consideration. And I'd say that tips the balance in favor of prejudice. But you've also got the testimony from the two ballistics officers, Leiden and Camper, which is the other.
I mean, the judge, in weighing the whom to believe between the officer's description of the hospital conversation and the witness's denial of the hospital conversation, surely can take into account the corroboration provided by the ballistics report, if and to the extent the judge believes that the science underlying the ballistics report offers sufficient indicia of reliability.
Well, I think those are two separate. They are, though, two separate issues, because really the question of, first, identity. Who's the person that committed the Chelsea shooting? That's one question. And if the evidence on that is weak, which our position is that it is, then that's a situation where you're telling the jury, you're allowing them to consider, well, maybe this guy did commit a shooting in Chelsea 5 months earlier. What's the real probative value of, well, maybe he did it? Our position is the probative value of that is weak, given the weakness of the evidence that he committed the shooting. You've then had the prejudice from it, which is very, very high. The telling them that the jury that he may have committed that shooting, now that triggers a response by the jury, which is exactly the response we don't want when we admit this type of evidence, which is the jury could think, where there's smoke, there's fire. Well, maybe there's a chance he committed the Chelsea shooting.
I thought the probative force of this evidence was to help to establish identity and access to the weapon that was used.
Correct, exactly. But it's only relevant if Michael Collins was in fact the shooter in Chelsea, and if the evidence
exactly. But I mean, but the ballistics report fuels into the determination that the judge is asked to make on how strong or weak the testimony of the officer witness as compared to the third party witness.
Yes, the ballistics. The other position that we raise in the motion is that the PCAST report and the evidence.
Counsel, before you get there, your motion for, this is just a quick procedural point. Your motion for new trial, the motion itself is based on ineffective assistance of appellate counsel, but your argument, your client's argument in the trial court, and apparently here, is that you want us to simply directly review whether there was error in the admission of the evidence. Do I understand your position correctly? Do we have to go through the hoop of ineffective assistance of appellate counsel in order to reach the evidentiary issue, or may we just review the evidentiary issue?
I believe we do have to review it as ineffective assistance of counsel, and appellate counsel did sign an affidavit in which she conceded that this was an issue that she should have raised. It was an issue raised and objected to.
So in addition to the substantive arguments you've made, we have to also leave the threshold question of whether ordinary fallible appellate counsel would not have made this argument.
Correct.
Okay, thank you. Now, you've only got 4 minutes left. Please.
But I want to get in here with a question. So you argue in your brief that the version of events testified to by Laguerre and Ms. Jones differed, and I just wanted to make sure I understood. So you mean the difference between who got shot first and whether Mr. Lawton was hit in the head with the gun and then shot, or shot and then hit in the head with the gun?
Correct.
Is there any other difference?
No, that is the difference between their testimony, is that they testified differently as to the order of events of the shooting.
Okay. So on the ballistics, can you explain what was allowed in that you think under the PCAST report should not have been allowed in?
Yes. So under what was allowed was that the officers were allowed to say that there was a match, that there was a strong probability, or that there was only a small possibility that there wasn't a that this wasn't a match. What the judge found in Tibbs, and what our position is that that's not what should be allowed. All that should be allowed is that the officer should be able to say that they cannot say that it isn't a match. That's what Tibbs allowed, is that the officers were permitted to say, we can't exclude this firearm as being the source of both shell casings. And if that was what was admissible here, then again, the Chelsea shooting has minimal relevance. Just to say that we can't exclude the possibility that these two guns, or that this gun fired both sets of shell casings, that's much, much different than saying that there's a strong probability of a match. Or
my understanding of the formulation that was of what's permissible and what's not was a little different than what you're framing it as now. I mean, I think that the point is they can't state a conclusion that that's what it was, but they can offer an explanation of how they got there and admit to the existence of uncertainty.
But only but they can. The difference is, can you say they were still allowed here to say there was a match. They were allowed to say there was a match between the shell casings and the firearm.
But
wasn't
there was uncertainty.
Wasn't the judge's ruling that they were permitted to testify to a significant probability of a match?
Right.
Correct.
Right.
Okay, there's a big difference.
Correct. That's to say there's a significant probability of a match versus what Tibbs held, which is we can't exclude the firearm as being the source of both sets of cut casings. That's a huge difference. And had that been
I agree there's a huge difference, but in the interim, we have Commonwealth versus Huang. And how are we, the position you argue for is one that appears to be foreclosed by that case. And we're not usually in the habit of reversing the SJC.
And I understand that. Our position is that the PCAST report in Tibbs, which came about after that decision from the SJC, they don't just lend additional evidence on an ongoing debate. Tibbs and the PCAST report, in our position, have ended the debate. They have examined everything that's out there, all studies, all experts that deal with ballistics, match and testimony, and they found it does not meet the Daubert-Lanigan standard. That's our position. The debate has been ended, and the Commonwealth has pointed to nothing in their reply brief to suggest that what we contend on that issue is incorrect. It is not generally accepted. There is no standard controlling the operation. It's plagued by inconsistent results when it comes to, I'm sorry, my time has expired.
Well, I think we have your point. Thank you, Mr. Gravina, for the Commonwealth.
Thank you, Your Honor. Kaylin Campbell on behalf of the Commonwealth. Good morning, and may it please the court. We ask you today to affirm the denials of the defendant's second and third motions for new trial. I'll start like my brother did with the denial of the second motion for new trial. And I think there's really two parts to this. The first is that, and this goes to a question that Justice Sullivan asked, the first submission as to the motion for new trial didn't have an affidavit associated with it at all. So Judge Roach certainly acted within her discretion when she denied it. As to the defendant also appealed the denial of a motion to reconsider. I would say the threshold issue, as the Commonwealth raised in its brief, is that the Superior Court didn't have jurisdiction at that time to even consider the issue, as the case had been transmitted to the appeals court. Even ignoring that, in the sake of judicial economy, the defendant has not shown that appellate counsel was ineffective. I think here it's important to look to the SJC Collins case, which decided the denial of the first motion for new trial and the direct appeal. There was extensive litigation and many issues that were raised in both the first motion for new trial and the direct appeal, which resulted in it being taken on DAR to the SJC on specifically an identification issue, an eyewitness identification issue. But even ignoring that, I think going to the merits of the defendant's claim, the Commonwealth couldn't disagree more that this is weak evidence of identification, and especially so where you're looking at the judge's discretionary call to admit this evidence. There was a motion in limine that was filed. Testimony was taken from John Arnold, who remitedly was a reluctant witness. There were questions posed about the grand jury testimony, and I apologize, I don't have the specific grand jury testimony before me, but John Arnold did testify at the grand jury, and I don't remember if he testified, Michael Collins was indeed the person that shot me, but he did admit that he had identified a picture of the defendant as the person who shot him. Even more than that, you have 3 witnesses, 2 Chelsea police officers who say—
Counsel, my understanding of the record, though, is that the motion judge did not admit that substantively. He only admitted it on issues of credibility.
Certainly. So if you're looking at what the jury had in front of them, it had 2 Chelsea police officers who testified. And I think this is important, and this can be found on volume 9, page 34. Sergeant William Dana of the Chelsea Police Department testified that a day after the Chelsea shooting, Arnold told him that Goody shot him. And then he asked Arnold point blank, "By Goody, do you mean Michael Collins?" Which Arnold said yes. So the jury heard that. They heard similarly from Detective Conley, and this can be found on volume 9, page 107, that Arnold identified the defendant from a photo array. True, he didn't sign his name, but he had his arm in the cast at that point. So it was difficult for him to write, which is what the testimony was. He also told a social worker who testified at the trial that he knew the person who shot him, and that it was over a disagreement. So I disagree this is weak evidence of identification, especially where at trial Arnold testified that he didn't want to be seen as a snitch, that he was reluctant to testify, and that he didn't really want to be there. That was clear to the jury when it was before them. Either way, we talked a lot about the omission of this testimony. We didn't talk about whether it was error, whether it would be prejudicial, and it wouldn't be. I think what we're looking at in this case is evidence against the defendant, which the SJC has already called overwhelming, but it includes 2 eyewitnesses in the apartment who identified the defendant as the shooter, an eyewitness that identified him seconds after the murder running from the apartment with a gun in his hand, evidence that Laguerre—
They didn't necessarily identify him by name, they identified him by his jacket, correct?
No, there was one eyewitness, Desmond Sheets, who looked at a photo array and identified the defendant's photo as the person holding a gun who ran from the apartment in the seconds after the shooting. There is another eyewitness who's across the street who identifies his jacket and him running out of the apartment in his jacket.
I just want to be clear, when you're summarizing both the direct pick the face out identification and the secondary identifications.
Absolutely. I think
Okay.
as to the pick the face out identification, there's witnesses who do that. This is a really strong identification case, which makes sense, right? Not to jump around, but it makes sense if you're looking at this, why you would really focus and challenge the identification and winnow out other issues which would seem less important than the identification issues. And certainly the SJC agreed, it went up on the identification issues, but even post the SJC's ruling, and even if you were to apply sort of Creighton and the rule announced here, Collins, to these identifications, there still are numerous both direct identifications and secondary identifications which support that the defendant was the shooter in this case. Not only that, you have corroborative—
But the Commonwealth wasn't content with Laguerre's testimony and the downstairs neighbor's testimony and the neighbor across the street. The Commonwealth did think it was necessary to bring in the Chelsea shooting for identification too, correct?
Absolutely. And my response to that is, did we need to? No, but we have to prove to a jury beyond a reasonable doubt that the defendant was the individual who committed this murder. And that's the way that we chose to do so.
Do you agree that in assessing the admissibility of the identification from the Chelsea shooting, that the judge should have taken into account the strength or weakness of that evidence that the defendant was the person who committed the Chelsea shooting?
And well, I would say insofar as I would say that the judge necessarily did, in that John Arnold testified in a motion. There was a voir dire of John Arnold before he testified, before a ruling was made.
What are we to make of the fact that no indictment ever issued of the defendant as to the Chelsea shooting?
I don't think there's anything to be made of that. I think if you have a witness who at the grand jury would be, I can't speak to the reasons why an indictment never issued. There are multiple reasons why an indictment may never issue, and it may be as simple as the defendant was indicted for murder 6 months later. He committed a murder 6 months later. It's not often that when you have someone who stands indicted for murder that you necessarily go back and charge lesser crimes that they may have been indicted for. So I don't think anything should be read in the lack of indictment as to that case.
So the defendant argues that the Commonwealth's case that the defendant was the shooter here rested primarily on the testimony of Mr. Laguerre. What do you say to that?
I disagree with that. I disagree. I mean, Laguerre was certainly a piece of the evidence. I believe there's substantial other evidence, including the identifications made by Jones, who was in the apartment, the two Desmond Sheets, who identifies him from running from the building, the across the street neighbor who identifies his jacket, and the other evidence such as the flight from the area and phone records, which corroborate sort of the timing of the flight, and then the defendant fled, which demonstrate the defendant's guilt in this case.
So what's the evidence that Laguerre said that Goody or Goldie committed this? I mean, because those are different, albeit not that far apart.
Your Honor, I believe that an officer testified that when a responding officer testified that Laguerre told him that. I think I'm trying to remember. I don't think that's dispositive to any of the issues the defendant raises. However, he's focused specifically on the omission of the Chelsea shooting and the omission of the ballistician's opinions as to ballistics matches. So I'm just, I guess I just don't understand the question insofar as it relates to the issues that were raised by the defendant.
Well, he's raising it as an identity question that in fact Laguerre had said it was Goldie, who's a different person apparently than Goody.
Certainly, and I disagree given the strength of the other identification evidence, as the SJC has held already was overwhelming in the direct appeal of this case, that identifies the defendant as the shooter in this case.
So we've heard on the identity of the firearm. Do you agree with the characterization from the defendant that the difference here is that he's saying that the experts and under Tibbs that the ruling would be that we cannot exclude the firearm as a source of both casings?
That's what Tibbs says. I would say that post the 2016 PCAST report and post Tibbs, and this can be found, my brother said that Tibbs and the PCAST report ended the debate. I would point to the cases cited on page 28 of my brief, which have held that this type of testimony is still admissible post both of those things happening. Ignoring that though, even setting that aside, really when you look at the reasoning in Tibbs, what they're talking about is that there shouldn't be an unqualified opinion which is given by a ballistician when they're talking about two mark comparisons. And that means the jury shouldn't be led to believe that there is 100% certainty that there is a match. And certainly the jury wasn't led to believe that here. But even setting that aside, if you take the defendant's argument to its logical conclusion, so if you take it to, okay, what is he alleging should happen here? The evidence, ignoring the first issue, but the evidence would be admitted. The jury would hear that there are these two shootings, two guns, that the defendant is identified as being linked to both of these shootings, and that the shell casings cannot be excluded from being shot from the same gun, which is found along the defendant's flight path. From that, the prosecutor still could argue, as the prosecutor did here in his closing argument, that the defendant was in fact the shooter and that the gun that was recovered did both of these shootings. So at a base level, it's unclear how, and this is important too, not that the Commonwealth is conceding that this is newly discovered evidence, but the standard asks whether there's a meaningful risk that a jury would have reached a different conclusion had the evidence been admitted at trial. The prosecutor could have made the same arguments.
Don't you think this is really a newly available evidence case, not a newly discovered evidence case?
It could potentially be a newly available, but what's interesting is if you compare and you look at the NAS report and the NRC report, which existed at the time of trial in 2009, if you look at the 3-day Daubert-Lanigan hearing that Judge Broussard held, if you look at really what they were talking about, it really is what the defendant is arguing here. Sure, he could point to a different study that is more extensive.
Right. And that's the reason why he's saying I get to argue it again.
That is why. But I think at the base level where it wouldn't have led to the exclusion of the evidence, where the prosecutor could have still made the same type of argument that he made in closing argument, there is no basis to conclude that there's any, let alone a meaningful risk that a jury would have reached a different conclusion.
What do we do? What do we do with Commonwealth versus Hewing? How does that factor into this?
It factors into it insofar as it exists, and it exists that there has to be a qualification to the ballistician's testimony. That qualification did happen here. Judge Broussard was prescient in the ruling that he made. I think it supports that there was no abuse of discretion in the admissibility of this type of opinion testimony, and I think it stands for the SJC. There is precedent which has a ruling on this type of evidence that this court is bound by. Now, that's not to say that there couldn't be a motion that's filed in which, it's tried to take up to the SJC whether they should change that in light of the PCAST report or in light of what has happened since 2011 when that case came out. But I don't think it's dispositive to any of the issues in the case here today.
And do you think with respect to the prior bad acts evidence that we have to look at this first through the lens of ineffective assistance of appellate counsel? Or is it possible on a motion for new trial just to look directly at the evidentiary ruling?
No, I don't. So to answer the question, there were two questions there. The first is lens through ineffective assistance. Absolutely, yes. That is the only way by which, after waiving it on direct appeal, that the defendant could raise it. So it should be viewed first through that lens. And it asks whether appellate counsel failed to raise a significant and obvious issue, which may have resulted in reversal of the conviction. And given what appellate counsel did do, which is shown through the Collins opinion, the SJC opinion, she did raise many strong issues that resulted in groundbreaking law. So, for the sake of judicial economy, the Commonwealth briefed the merits of it in case we got there. But
after Commonwealth versus Randolph, you can raise a motion on something on a motion for new trial that wasn't raised on direct appeal, and it's just reviewed for substantial risk if it wasn't preserved, right?
I haven't, quite honestly, I would have to read Randolph again. This was raised in an ineffectiveness posture. So I would say the court should consider it an ineffectiveness posture, because the question is whether Judge Roach abused her discretion or committed otherwise an error of law in denying the issue that was before her. So I would say because of the way that the issue was raised, that's the way that you should consider it.
Okay.
And if the court has no further questions, the Commonwealth will rest on its brief.
Seeing none, the case is submitted. Thank you both.
Live and recording.
The next case on our list for hearing is case number 2019 P621. the Commonwealth versus Michael Rodriguez. I will just remind everyone that from time to time, we may be looking off to the side. That's because our notes are off to the side. It does not reflect any inattention to the arguments that you are presenting. And with that, you may begin.
Good morning, Chief Justice Green, Justices Henry and Sullivan, and may it please the court. My name is Robert Hennessy. I represent the appellant Michael Rodriguez in this case. Nearly 10 years ago, in Commonwealth versus Bishop, the late Chief Justice Gantz, writing for a unanimous Supreme Judicial Court, recognized that the pejorative use of the word nigger in reference to an African-American man or other person of color, quote, poses a risk of inflaming a jury's emotions matched by few other words. Chief Justice Gantz was not in any way alone in his assessment in this regard. Other courts and commentators have characterized that word as, quote, the most offensive and inflammatory racial slur in English, the most, quote, provocative, emotionally charged and explosive term in the English language, and, quote, the nuclear bomb of racial epithets. Chief Justice Gantz admonished in that case that before a judge admits evidence that a defendant used this word to describe a man of color, the judge must be convinced that the probative value of such evidence justifies this risk. At issue in this case is the admission of uncorroborated testimony by a jailhouse informant alleging that Mr. Rodriguez, on 2 occasions approximately 5 years after a fatal shooting for which he was standing trial, used the word nigger to refer to the decedent, an African-American National Guardsman. In the circumstances of this case, where the Commonwealth did not prosecute under a theory of racial motivation or racial animus, and there was no evidence to suggest such a theory, and where the central issue at trial was whether Mr. Rodriguez acted justifiably in self-defense or in the presence of mitigating circumstances that reduced his culpability, the disputed racial allegations were devoid of probative value, not substantially outweighed by their uniquely inflammatory nature and their predictably prejudicial effect on the jury. The judge's admission of...
Counsel, the Commonwealth contends that prior to the defendant's own testimony, there was no evidence that the defendant had confessed to killing the person who was shot here or to possessing a firearm on the night of the shooting. What do you say to that?
Well, I would say that in terms of the possession of the firearm, the use or non-use of the pejorative racial epithet is irrelevant, entirely irrelevant, because that's not connected to having a gun. It's connected to the shooting itself, is my understanding. And with respect to that, clearly the defendant testified in the defendant's case, not prior to the Commonwealth's case in chief.
Right, but she's basically saying nobody identified him. None of the other people, the victim's friends, that nobody had identified the defendant. So him saying he shot this soldier and even saying the race of the soldier, I think that's what she's saying, is some identification.
Well, I think that there may be something to the idea that him making a statement, a contested statement, that he shot a soldier is relevant to identification, even in a case where he himself subsequently testified. The question in this case is, what is the relevance of the use of the word nigger in that context?
Okay,
But the point
can
here...
I just break down
Yeah.
one piece? Is she correct that none of the witnesses were able to identify the defendant as the person who shot the guy who got shot?
Well, all of the Commonwealth witnesses who were in the car with the defendant on the night identified him as the person who was in the car and then stepped outside of the car and then got back into the car. In terms of the witnesses who were with the decedent who saw the shooting, I don't think any of them none of them had identified him in a pretrial lineup. Therefore, under Creighton, could not identify him at trial.
Okay, so continue, or the chief might have had a question for you.
Yeah, I did have a question. I mean, I think that what makes this case difficult or different from the case that you were alluding to earlier is that the use of the epithet is embedded in an admission of guilt. It's what I suppose what you're arguing is that the only way in which an admission that itself includes a racial epithet may be admitted is by redacting it. But I think that there is a sense of context and completeness that that becomes very delicate when you're suggesting that the precise words of a defendant uses in admitting the charged act. I think you get into very dangerous territory.
Well, I would disagree, Chief Justice, for a couple of reasons. One, that is exactly the analysis that the SJC engaged in the Chalou case. That reference to the nigger as one of the 3 victims that this person was admitting to have killed had no place even in the context of an inculpatory statement. And in terms of the idea that this is embedded in a statement, this is not a situation like almost all of these cases where we have a jailhouse recording or other recorded testimony in which this word is used. We have the uncorroborated allegations of a jailhouse informant who chose to include that word in his reference. So the idea that this would take some sort of redaction, I think, is just not accurate in this case. I mean, in the Rosa case.
Wait, whoa. Are you saying that even redacted, the admission may not be admitted?
No, I'm not saying that at all. I'm saying that the admission could be admitted and had probative value, and if it had the word nigger been redacted from it, it would not have had the overwhelming prejudicial effect that it did as presented.
As I understand it, that was defense counsel's request. As I look at the transcript, he asked that the word be redacted. And the Commonwealth said, well, that's not the complete statement, and it can be hard to get witnesses to redact a word, and ultimately the judge decided to let it in. I have a different question, which is, as our case law has demonstrated, sometimes that word is an epithet and sometimes it's not.
Correct.
How do we know that it was an epithet in this case?
Well, I mean, first and foremost, I would say we would know by the fact that that's exactly how, the trial judge characterized it as an epithet.
Well, I know we did, but it's also a polite way of not having to use the word, which most judges are not going to want to have to use.
Sure, no, of course.
So and it's not what the judge thought, it's what the jury thought. And the defendant testified, A, that he doesn't use the word, but also that his grandmother is Black, his ex-wife is Black, and his child is Black.
Sure.
So how do we know, given that context, that this was used as an epithet?
Well, one of the ways, I think, culturally at this point, because we're touching a lot of cultural touchstones, is that the use of the hard R in it. This is about the nigger soldier I shot, or maybe this is about the nigger soldier I shot, is in and of itself sounds different to the ear, to a lay juror, than, for example, N-I-G-G-A, nigga, which is the version that was used repeatedly in the Rosa case, and used so often and so obviously as a term of affection that the judge in Rosa said, this is not a pejorative use, and it's being used so often that it couldn't possibly be redacted. I will redact as much as I can, but it couldn't actually be entirely redacted.
So let's accept that view of it.
Okay.
I don't know, none of us know how it was used. We don't know whether this is NWA or whether it's something else, right? But it's used as an adjective, which is not good.
Sure.
And what's interesting about the statement, given his defense of self-defense, is he doesn't say, oh my God, that's the man who tried to kill me and I had to shoot him. He says something quite different. And in the context in which this statement comes out, can the use of the N-word be viewed as demonstrating a lack of respect for human life?
I don't think so. I think
statement
I think that theory of relevance, first of all, was never proffered by the Commonwealth. Let's just be clear about that. But secondly, and never even suggested by the judge, who made absolutely no findings in this case. I think this would be total speculation that it could be, and I feel like we would be out on a limb.
I don't know that it's speculation. You hear it and you think, whoa, that's tough, right? That's rough. Even taking the racial component out of it, you think, whoa, that's cool.
Yeah, so with the racial component of it, it's like this must be about the soldier I shot. That has, I'm not sure that has quite as rough or quite the same impact as this must be about the nigger soldier I shot. I think that they're different in kind.
They are different in kind, but in multiple respects is my only point.
Sure.
And does the fact that you could import many meanings to the use of the word in that context take this out of the realm of abuse of discretion?
Well, I don't know that it takes it out of the realm of the recognized inherent inflammatory nature of the actual word that we're talking about. So, I mean,
what if the defendant had said, "Yeah, that's the dude I shot"?
Then that would not have been an issue. It would not have been an issue that I'd be raising in this case in this way.
Right.
At all.
Right.
Yeah. No. It is literally and as
it would still be cold. It would still be cold, but it wouldn't be raising.
It would still be cold, but it wouldn't carry with it all of this recognized tendency to sweep jurors beyond a fair or reasoned consideration of the facts and into like a very, understandably emotional response to certain kinds of language.
Let's say we assumed that your argument prevails. I'm not saying we would, but if we did,
okay.
I think we need to talk about prejudice, because that testimony did come in about the defendant's own racial background. I know your brief says he's white, but the testimony is that he's light-skinned, he's got a Hispanic surname, and he testifies to coming from a family with 3 generations of Black family members.
Sure. So, number one, I don't think that being forced into the position of spending your time when you should be testifying to your recollections of the evening, trying to prove to the jury that you're not a racist based on other testimony that never should have been admitted, is meaningful mitigation. And I don't think it cures the problem with the attribution of this from the get-go. I think there's, and I do cite a case for that proposition, that being forced to speak and try to do your best that you can do with evidence that never should have been admitted is not mitigation that eliminates the prejudice caused by the language. And the language here, I mean, again, I come back again over and over again to the what Chief Justice Gantz described as the unmatched inflammatory risk that this one specific word carries with it.
Well, it's unmatched if the person who says it is white. Is it unmatched if the person who says it is Black or has Black family members?
Well, I think there may be more. It may be a less clear situation where this is. I think it opens up greater possibilities that this was not being used in a pejorative sense, if it's a person of color using the word. So, but Chief Justice Gantz does say used in reference to a person of color. That's that, and which is why this idea that the Commonwealth has proffered about this is relevant to identification is so circular and so absurd when you play it out to its logical conclusions, that this is relevant in a case to show that this person knew this person was Black. The use of the word nigger is relevant to show that they knew that they were Black. I mean, Chief Justice Gantz and all of these cases are very clear that it is the use in reference to a person of color that makes it so prejudicial. So,
if I could switch gears on you for one moment, would
Sure.
you agree that Exhibit B, which is the instructions that were sent into the jury room, has the correct statement of the burden of proof, and that the incorrect statement was verbal only?
Yes, I reviewed that for the first time the same time the court did. We weren't unable to get a copy of it earlier until yesterday. So I would agree, I did review that section, and I agree that it is correctly stated in the written instructions.
And by the way, I was remiss in not saying earlier that we all thank you for getting all of those materials to us so quickly, and we were able to review them in advance of argument, so thank you.
You're welcome, of course.
So switching gears, the Commonwealth argues that Chalui doesn't help you as much as one might think, because there the court held there was no substantial risk of a miscarriage of justice. What do you say to that?
I would say that that's the wrong standard to review the claim that we've raised in this case. In Chalou, that was an issue that was not raised by defense counsel at all below or on appeal. It was reviewed under the 33E authority and under the standard that they apply there. Here, the the issue about these being more prejudicial and probative was raised over and over again. There was an objection every time the evidence came in. The defense counsel pleaded with the judge, please just keep this one word out. That's the overwhelmingly prejudicial aspect of this testimony. The judge denied that without comments. They just said, we're going to give this to the Commonwealth. He never explains any of his reasoning. And so the fact that is, the Chalou analysis is put into that section, I think is it's just a diversion.
Right, I think we'll have to leave it there. Thank you. We'll hear from the Commonwealth.
Thank you, Your Honor.
Reminder, Mr. Hennessy, if you could put yourself on mute.
I will. I'm just going down.
Good morning, and may it please the court, Assistant District Attorney Kelsey Barron for the Commonwealth. Your Honors, I'd like to begin with the initial instance of whether or not there was an abuse of discretion related to the jury trial judge's denial of the defendant's motion to eliminate and the allowance of that witness to testify. And I would suggest to Your Honors that there was no abuse of discretion here. Again, the question here is whether or not the statement as a whole, including the potential racial slur or the actual racial slur, was prejudicial. And the Commonwealth does not shy away from the fact that, yes.
Counsel, you had argued this was waived. Do you agree it was preserved, just this particular thing about using the N-word?
Yes, Your Honor, I would state that the argument that this was a prejudicial statement was preserved properly. However, the argument that this might have been a prior bad act, that was not properly preserved and should be looked at through a different standard. But the argument that this was a prejudicial statement was properly preserved and should be looked at under the context of whether it was probative versus prejudicial. And the Commonwealth does not shy away from the fact that that type of word is in fact undeniably prejudicial. But the question here is whether it is unduly prejudicial. And I'd suggest to you that it is not in this circumstance. Rather, the use of that slur as well as the entirety of the statement, which is what the Commonwealth was seeking to admit, is incredibly contextual to the case at large. And because of that,
right, but counsel, what's the probative value of including just the N-word versus having the informant say that the defendant said, I killed that soldier, or even I killed that black soldier?
Well, first of all, Your Honor, by saying that black soldier, I would suggest would be a misstatement of what the defendant is alleged to have said in and of itself. So that would be incorrect evidence to provide to the jury. But to take out the word entirely in the two instances in which it was going to be given to the jury, I would suggest to you, Your Honor, is a sanitation of what the defendant said. This is an instance where, again, the Commonwealth—
Isn't that what a redaction always is?
Correct, Your Honor, but I suggest that redactions and sanitation are necessary in certain circumstances, and in this it was not. As you saw in Commonwealth v. Rosa, that was an instance where the judge did decide that there was sanitation that was required and redactions that were required.
But counsel, Rosa is a completely different case. In Rosa, there was testimony that the defendant used the N-word like some people say guy or dude. That is not what was going on here, and that does not appear to be the purpose of having admitted the work.
Your Honor, the Commonwealth was not looking to ask the word to be used so that it could create racial animus or even bring that to the jury's attention. It again was an intent to bring in context, as was argued by—
What other context is there in this case?
Identification, Your Honor, as it was stated earlier.
I saw him shoot the soldier. That's all you need.
Again, Your Honor, I would suggest that by redacting that word and sanitizing it, first and foremost, as was argued by trial counsel, would be incredibly difficult for a witness to do. However, Your Honor, we also did provide the transcripts of the phone call that was read to the jury, and that would be, again, a redaction there. And I'd suggest, Your Honor, redacting that at that moment, just 2 moments, would allow for a lot of speculation on a jury's case, on a jury's part. And again, Your Honor, I'd suggest that
let me I guess push back on both of those assertions. The first, yeah, it may be difficult for a witness to do, but we have responses to witnesses make misstatements on the stand following limiting instructions all the time. And whether it requires a mistrial, whether it requires an immediate curative instruction, whether it requires an admonishment and a reminder is a question. But the mere fact that it may be difficult for the witness to comply is not a reason to allow impermissible material to come in. And it seems to me the force of the argument is even less strong when we're talking about reading a written transcription of a verbal statement. There, the opportunity to edit. So your argument, it seems to me, always devolves back to the need for verbal completeness. And the question, when we get back to probative value versus prejudice, is why is this one word within an otherwise complete admission going to identity so essential?
Again, Your Honor, I would suggest that, again, it's all about context in this circumstance. This is an instance where the Commonwealth was bringing forth a theory of murder in the first degree, or alternatively murder in the second degree. And this was an instance to show callousness, a lack of remorse, a lack of interest in this human being's life, that this person many years later still referred to him with such deep disrespect was very important to the jury to be able to hear. And again, Your Honor, this was again.
So if I understand you correctly, what you're saying is that the racially inflammatory nature of the statement is precisely the point.
No, Your Honor, I apologize if that was misunderstood. What I'm stating is to allow the defendant to speak in his own words, and his own words were words that were callous, were unmeaning.
Yeah, but we have limitations on which words can be used, and you know, I understand your concern that we don't want to rewrite history, but I guess I'm having a little difficulty understanding how you can reconcile your desire or objective with the admonishment that comes out of Chalou.
Your Honor, I'd suggest again, under Chalou, they did state again that yes, this word is incredibly prejudicial. It is problematic. However, when there is a outweighed of probative value, that prejudice is undermined. And I'd suggest that that's what we have here. This is a circumstance, Your Honor, which it was stated earlier, the Commonwealth was attempting to piece together a case for a jury where there was no direct evidence of who the defendant or who the shooter was. In this case, both of the victims' parties who were with him did not know who the defendant was. They had never met him.
But counsel, can you address why the redaction of the word does not suffice then? That's all the defense counsel asked for, and frankly, the response of the Commonwealth in that moment is a little mystifying to me. Defense counsel says the admission that he shot him can come in, the reference to a soldier can come in, just take out that one word. So why does that one word have to stay in?
Again, Your Honor,
For
I would
context.
suggest, yes, for context, and I do believe that it
What
is important.
context?
The context is, I'll go back to the comment I made before that you.
So let's let her answer.
Well, okay, but I mean, okay, go ahead.
The context again, Your Honor, as to who the victim was, and that he was known, or at least at the time of the shooting, who he was as a person was unknown to the defendant, yet he shot him anyways. But 3 years later, or many years later, after learning about it and seeing about it, he knew exactly who it was. He knew exactly what had happened. He knew the backstory. He learned all about it and still had a callous nature towards it. I'd suggest by sanitizing the defendant's own statement.
But also, we don't convict people because they had a callous nature, or because maybe after the fact they're justifying them to themselves why they did what they did.
Your Honor, I'd suggest that his statement doesn't justify anything to himself. However, it does point out, again, that nature of extreme atrocity and cruelty of someone who saw another person, got angry with them, and shot. The Commonwealth had gone over, had presented a case for murder one, and that was the intention that we were going with. Ultimately, he was convicted of murder in the second degree, and I would suggest again that it shows that the defendant knew exactly who the victim was, knew that he had taken out a gun, knew that he had pointed it at him, knew that he had chambered around, and knew that he had shot him regardless. I'd suggest again, Your Honor, that it is contextual in nature. Again, the Commonwealth.
So did I understand did I understand you earlier to say that the N-word was used during the jailhouse call?
It was used twice, Your Honor. Well, for context, in the Commonwealth's case in chief, we presented a transcript of a phone call between the defendant and a third party, as well as the witness. It was after that phone call that the witness testified that he spoke to the defendant, and while speaking with the defendant on an unrecorded line, no recording of it, that is when the statement was made. He also testified that secondarily, outside of the jail, during a conversation between himself and the defendant, the same statement was used. If I misspoke, I apologize.
I thought you said on the transcript that the defendant used the N-word.
I may have said that, Your Honor, and if I did, I misspoke, and I apologize. If I could clarify now, the N-word was never in the actual transcript itself. It would not have needed to be redacted from that. The only redaction would have had to be from the person or the witness himself. He would have had to have
There's
written.
no evidence that the defendant used the N-word on the night in question, right?
Correct. There was no indication of that. Partially, Your Honor, is because, as was stated earlier, the two witnesses the Commonwealth put forward who were with the victim had testified that they could not hear what the argument was or the conversation was. They could not hear context. And also the two witnesses for the Commonwealth who were with the defendant at the time stated that they saw him get out of the car. They heard a ruckus. They heard loud noises. They saw him get back in the car, and then they drove away. There was never any connection of the defendant to A, the gun, or B, to the actual animus that happened. So the Commonwealth is suggesting that, again, we are not shying away from the fact that that word is in fact prejudicial. However, we are suggesting that the prejudicial nature of that word is wholly outweighed by the overwhelming probative value of that statement in whole. Again, it is an open confession that while a redaction may have been made, I would suggest was not necessary or needed at the time, given the context and the importance of it. However, again, getting to the argument that was brought up earlier, the question earlier of Cholula and whether it applies, I'd suggest, Your Honors, that that is a different circumstance here. As stated earlier in appellant's brief, he does repeatedly go to the prior bad acts law, and he does bring up this case as a prior bad act. I'd suggest that that argument was waived at trial, or was waived at during the motion to eliminate. It was never brought up in the motion to eliminate. It was never brought up at trial. It was never brought up during anything until this brief. And I'd suggest, based on that, Your Honors, that he had waived the argument, and it needs to be looked under a substantial risk of a miscarriage of justice.
So
Let's
counsel,
then, go ahead, Judge Henry.
the defendant says that below you argued that the use of the racial slur was admissible to show the nature of the defendant's relationship with the jailhouse informant. But I don't see you arguing that on appeal. Am I correct about that?
Correct, Your Honor. Your Honor, again, as a
Let's go to prejudice with only 3 minutes left. If we were to disagree, if we were to conclude, and I'm not saying we would, that the admission of the evidence of the word was improper, not the statement, but the word. How do you analyze the prejudice? Given that this is given, let me just let you know how I see this, which is that this is a first or second degree murder versus self-defense case where the key events occur off camera, right? And nobody can see how this went down.
Correct. With that in mind, Your Honor, I'd suggest that the prejudice, again, is mitigated. Throughout the entirety of the trial, again, that word was used twice by the witness. It was never again brought up in any context. The concept of race was never brought up in any context. It was not until the defendant's own testimony himself, where again, he stated his own racial background, his own feelings on the words. Again, it was then the jury was given proper jury instructions as to the weight of testimony, whether they would take that witness's testimony, believe him or disbelieve him, as well as the defendants. Do you believe him or disbelieve him?
But on the evidence, counsel, I understand all the arguments about the instructions. I think we all do. Let's look at the evidence. What about the evidence in this case suggests that self-defense was not a viable defense, that the jury wouldn't have seriously considered it? Because this is preserved error.
Your Honor, I would suggest that there was significant evidence to show that self-defense was not accorded. You'll note, Your Honor, that again, there was testimony over and over again, including from the videos that were provided to both the trial court, the jury, and yourselves, shows that the defendant was standing, he's approached the victims first. The victim approached, he was not charging, he was not running, he was not aggressive, he was walking forward. That he approached after the defendant began walking away. As he continued to approach, there was testimony from not only the two precipient witnesses, but also the defendant himself. There was no physical altercation of any kind. The victim never touched him in any way.
So are you saying though that the defendant had to let someone who was the same height but weighed 60 or 70 pounds more had to let him punch him before he could engage in self-defense?
Not at all, Your Honor. I'd suggest that he continued on, that he had opportunities to walk away. He had opportunities to get into the open car door that he also testified to, that there were several moments when he could have left. He said he actually picked up the gun, chambered around, pointed it at the victim, all while never seeing a weapon himself. I'd suggest, Your Honor,
but he testified that the defendant had that the decedent had his hand behind his back, so he thought he could have a weapon. And the friends testified that they were telling the decedent that the guy had a gun, and the decedent continued walking forward and got to within a foot or two, according to your case, they got within a foot or two of the defendant before the defendant shot him.
Yes, Your Honor, and I agree with all those facts. However, I would suggest to you that, again, the Commonwealth put forth its case the way that it would suggest that there was no aggressive nature of anything. It was a meeting of two humans. And at that point, the defendant is the one who upped the ante and brought a gun into the circumstances. The defendant then had the opportunity to present his version of the case, was that he was afraid. And it was up to an unbiased jury who was properly instructed to make the determination on whether or not they credited the Commonwealth or they credited the defendant. And in this case, I'd say that they properly credited the defendant's case, or the Commonwealth's case, excuse me.
That's the question. How do we know that they properly credited the Commonwealth's case when a word of that nature got imported into the trial?
Is that a rhetorical question, Judge Sullivan?
I guess it is.
I do actually I'll phrase it differently, and it's not a rhetorical question. If we say it was error for the judge to allow the witness to testify that the defendant had used the N-word, then how could what's the path that your best case to say it was not prejudicial?
Again, Your Honor, I would suggest that if it was error to include it, the fact that there was a limited usage, that the Commonwealth did not harp on the circumstances of race, that it was never put in front of the jury as a racial case or a racial component, that it was not something that was asked of the jury to consider in any fashion, that given all of that, Your Honor, that may the prejudicial effect have been there, the probative value of the actual statement itself, as well as the completion of the Commonwealth's case, overrides any potential prejudicial effect and allows for the probative value to stand. If there are no further questions, the Commonwealth would rest on its brief.
You seem to have exhausted the panel. I see no questions. The case is submitted, and we will continue with the next case on our hearings. Thank you both.
Live and on the record.
All right. The next case on our list for hearing is the first of our civil matters, case number 2021 P207. I will remind those watching on our YouTube stream, as I've just reminded counsel, that we all on the panel have our hearing notes and other case materials on typically iPads or another screen away from the cameras that we are using for the Zoom conference. And when we look away, we are doing so to consult our other materials and not out of inattention to the hearing. I ask counsel to mute yourselves while you are not actively arguing. If you remain on mute when it's your time to argue, I will remind you of that. With that, Mr. Hession, you may begin.
Thank you. May it please the court, my name is Gregory Hession. I represent Susan Gallagher, the plaintiff, in what are three summary judgment matters that are all factually interwoven. I know the court has always become familiar with the facts, so I won't belabor that, but I feel like the key point here is that this is a case that's going to determine where the line is for issues like community caregiving, and where an emergency turns into a situation where officer or elder care worker can enter a home, and where the medical establishment is allowed to keep a patient against request of a proxy caregiver. And the first general observation I want to bring up is that the big issue here in the summary judgment is really a substantial number of arguments of fact. There are, throughout the briefs, all of the briefs highlight a very large number of factual conflicts. The first one being whether there was actually an emergency that allowed the defendants to enter Ms. Gallagher's home in the first place. There were a number of facts involved in that. Did they imprison her did they commandeer her home? Did she realistically feel as though that she could not leave and that she was being held against her will? Could they see into this condominium and actually see Father LaPlante in there in what they allege is distress? What she alleges is not. Was he in distress? She alleges there was no distress. Was she?
So, counsel,
Yeah.
on your MCRA claim, are you arguing she was threatened, intimidated, or coerced, or what specifically of those are you arguing?
Yes, she was threatened, intimidated, and coerced, and I'm not sure which of those the statements are. Those three criteria are so interrelated, but again, it's a largely an issue of fact. But she characterized in her in her deposition, and we excerpted a lot of it in the memorandum, that she felt like she was being raided, that they commandeered her. They brought in a third individual, another officer, to keep her from being able to leave or to be able to do anything until they made their determination what to do. So, and I cited the four really sort of old and established cases that don't require physical violence or anything to establish that. There's the Planned Parenthood.
So what she was forced to do was have these people in her home and to let them take him to the hospital over her objection.
Over her objection to enter. Again, a factual dispute, but she says, you have to get out. She told them right from the beginning, get out. But she felt right from the beginning when they went in, they did not really have an opportunity to see that the elderly retired priest involved here, who was 95 at this point, very infirm. They could not have seen him in the condominium. We've attached pictures to show that.
Yeah, I recognize that the judge, the defendants don't necessarily seem to understand that that's going to be a dispute of fact that would result in them going to trial. But the judges on the summary judgment totally sidestepped that issue so that there wouldn't be a dispute of fact.
And there was a number of them like that. You know, was he in medical distress? Was there really a reason or a medical reason for him to even been taken to the hospital in the first place?
Schoner is basically contending, and the motion judge ruled that her just being in the house and not leaving when asked is not sufficient. That puts her in a different category, perhaps, than Pompeo. What do you say to that?
Well, I really don't think so. And she pronounces her name Schoner, we found as we dealt with her. So she entered the home. She, according to the facts in the case, ordered Miss Gallagher to come down from her second floor gallery and ordered her to produce papers to show that she had authority to even be a caregiver for this priest. And she stood, in essence, guard along with the other two to ensure that that she was not able to leave or take any actions until these three apparently made a joint decision to remove the priest from their house. I think she was involved in the entire process, and I think the facts support that. But again, that's a dispute of fact.
Well, are you claiming that Pompeo was acting at her behest or direction?
At Scherner's direction? Well, at some point she was. I think sometimes Officer Pompeo was the one in charge, and other times it appears to be Scherner's in charge. For example, a little further along the situation, Ms. Scherner ordered the hospital not to release the priest, even though all tests had been done, and until Monday. They apparently were done on Saturday. Ms. Gallagher requested that she be allowed to leave again because all these tests were done, and the hospitalist told her, no, you cannot leave. Ms. Scherner has said you cannot leave until she gets here on Monday. And to confirm that, Ms. Gallagher had her attorney there Monday waiting for this option here, because the attorney was at this point involved in trying to get release of the priest. So
Wait. Just to be clear, when she was told she couldn't leave, she was told she couldn't leave with the patient, right? Not
with the patient. Yes. Yes, there was originally a false imprisonment claim on behalf of Ms. Gallagher that was dismissed early on in the case. It was only on behalf, but essentially they're sort of tied at the hip in that the priest was not ambulatory, so she had to be with him if he was going to leave. So
if he was going to leave, yes, I get it.
He was going to leave. So the real issue is whether he could leave or not, and he could not have left on his own without her assistance in a wheelchair.
Can we go back to the house for a minute? Is there any evidence as to whether or not Officer Pompeo was in uniform?
Pardon my not remembering this, but I believe she was, and she was well known to Miss Gallagher because they'd had an encounter 2 days before. Right. She had come to the home, seen.
If I could, counsel, my follow-up question is, was there any evidence as to whether or not Officer Pompeo was armed?
I believe that that's in the record, that she was in uniform, which would have implied that she would have had her sidearm. But I cannot reference the exact place in the record of that, but I believe the record will show that that's the case. Yes.
So back on the MCRA claim, and we're back at the house.
Yes.
The motion judges basically concluded that since the patient slept through or was unconscious through this whole experience, that he does not have a claim on this ground. What do you say to that?
Oh, I believe he does, because certainly somebody can be falsely imprisoned even if they don't know.
No, I'm not talking about false imprisonment. I'm talking about the civil rights claim.
Well, certainly, even if he didn't know, even if he did not know this, his proxy caregiver was trying to work on his behalf to ensure that he was not removed from the house, and that removal, I would submit, is was essentially communicated through his caregiver, Susan Gallagher. So,
is that communication necessary to the answer to Judge Henry's question? I mean, suppose he was not in ordinary need of a caregiver, but was otherwise simply unconscious for some reason.
Well,
or asleep.
I guess that gets to a more extreme circumstance than occurred, and I think it gets a little gray there. But certainly, Ms. Gallagher said on his behalf, "No, you cannot do this," and threats, intimidation, and coercion were occurring in that home. I think is amply laid out in the fact pattern that you cannot leave. We're taking him against your will. We're going to seize him against your right to be not seized. And I believe that what could be more intimidating or threatening than having that happen to a person you've been caring for years. This is it was just astounding to her. The words she used, she felt it was a Gestapo raid. I mean, I know people use sort of excessive language, but that's how she felt was happening in her home. So I don't think it's an exaggeration to say that this went way past these sort of baseline cases that we've all seen, the Planned Parenthood case, the reproductive rights case, all that. There wasn't even as much situation there. For example, the one in UMass, the reproductive rights versus UMass, they simply just wouldn't let students have their planned gathering to protest that they wanted to on campus, and they had posted guards. And they simply had a room that they were going to be able to use. They weren't allowed to use it. And that was ruled that constituted threats, intimidation, and coercion. Planned Parenthood versus Blake case, similar. They weren't allowing people to go into a clinic. The Bachelor versus Allied stores, they weren't allowing a person to distribute pamphlets on a store area. I mean, all these cases didn't involve physical violence. They involved the official prohibition of being able to exercise one's protected rights. And I think that's where we need to focus here.
If I may pose a hypothetical to you, this is not this case. Let's assume that elder services in a particular town and the police have documented reasonable suspicion to believe that there's elder abuse going on in a home. What in your view is the procedure that they are required to follow in the event that the homeowner bars access to the home to permit an investigation?
Well, the statute actually clearly has a process. When in chapter 19A is the elder abuse chapter, and it goes through a whole process of the investigation procedures and what the rights are, and so section.
But you correctly point out that there's nothing in that statute, and correct me if I've misread your brief, and the statute, that there's nothing in that statute that permits entry into a home. And that's what I'm trying to get at. What is the proper, in your view, what is the proper mechanism or procedure to enter the home over the objection of the caretaker?
Well, I think I can answer that fairly reasonably. The section 19 permits an owner to reject entry. Section 20 has a provision to get an emergency order, which is what Scherner attempted to do while Father LaPlante was in the hospital. On an on-call judge, the judge can permit an emergency intervention under Section 20. And then an even more immediate opportunity comes with this community caretaking exception. That's actually, two of the opposing briefs point out the new Supreme Court case, which I think is
We got your 16 out letter.
Yes, and that would allow that would allow, if there's actually somebody in known emergency distress, that there would be an opportunity to enter and alleviate that distress. Can't go in to get evidence if that's the only reason, if it's just pretextual to go in and get evidence to show that there may be distress.
So what do you do in the instance where there are credible reports that it looks as if someone is at risk?
Well,
and they may be unconscious and lying in their own urine, but they have been unable to verify it. Does Section 20 permit a judge to order entry to the home?
That is a really, we always get to these gray areas, and I think that unlikely that would permit that. I mean, in this particular situation, the reason that Father LaPlante was in his urine is because he had slept much too late, because he had such an exertion the day before. He was going to be changed, as he always would be, in the morning because he was incontinent, and certainly that was about to happen. But this was not a distress, and the hospital later confirmed that he was not dehydrated, and they really confirmed, thankfully, and the medical notes are in there from the emergency room. Both of his doctors were talked to. Excuse me, his primary care was talked to by the physician at the emergency room, and his other doctor examined these notes to find that there was really not a problem. So, you know, I think we're factually on the bright side of the road on this one. And I guess I would just say that almost every single one of these issues really revolves around a dispute of material fact. And if there was one thing I could say, that's where we're going here.
So, counsel, on the trespass claim, the motion judge related to Scherner said there was no evidence of injury or loss, so you couldn't prove trespass. Do you have a response to that?
Yes, I think that there was a substantial injury and loss. That she had her home intruded into. She had emotional distress from all of this, and she had the priest that she cared for years taken right out from under her and kept from her. And this was a really very substantial injury to her rights.
Okay, and I did have a different question, and I'm happy to have any of the defendants answer it as well. It feels like part of this case is circular because you have the officer go on June 23rd and learn from Ms. Gallagher that she left the father in the care of two people while she goes grocery shopping. And so the officer finds out about that after the fact at a time when she can see that he's fine. He's sitting eating his Burger King. And then she reports it and then they come back out to investigate it. So, but she's already talked and already investigated. Am I missing something here?
I believe that's exactly the fact pattern.
Okay.
I think you hit it right on the button.
Okay.
So I see my time's expired, and I appreciate you considering these things. And it's really, I believe that the material fact issue is ultimately where the court should make the change in this ruling on the summary judgments. Thank you.
Attorney Hession, and observing that your time has expired, you took the words out of my mouth. Thank you for your presentation. We will continue with argument from the defendants. They've agreed to divide their times, beginning with Mr. Lewison for 5 minutes.
Thank you, Your Honors. May it please the court, I represent Jennifer Pompeo, the Weymouth police officer. And, you know, with the time that I have, when we're talking about whether they're genuine issues of material fact and dispute, I would suggest that the only genuine issue of material fact and dispute is whether or not Officer Pompeo could have seen Father LaPlante lying on the couch from the door, which is disputed by the plaintiff. The other aspects upon which Pompeo made a decision to go in there are not really in dispute. And
right, so counsel, you've left me confused about that, because if the motion judges very carefully sidestep that issue. If we have to address that issue, you have a dispute of fact and there's no summary judgment. So are you sticking with the idea that the officer could see him from the couch?
yes, I am, but I understand that it is in dispute because it is disputed by the plaintiff. But what I'm trying to say, Your Honor, is that that's only one of the considerations that Officer Pompeo made to go in there. And she could have, even if that was not an issue, there was the concern that Father LaPlante was left with strangers, that they had knocked on the door, there was no answer.
She'd already been, to the question I asked Ms. Gallagher's counsel, she learned about that after the fact, and at a moment when she could see that he was fine, she had clearly already expressed her disapproval of that to Ms. Gallagher. There was no evidence Ms. Gallagher had done it again, right?
Right.
And so they're back investigating the thing that Officer Pompeo had already talked to Ms. Gallagher about, and now they're investigating it again.
Well, because
and you have Ms. Gallagher who I'm really at a loss, but Ms. Gallagher calls and says, I want someone to sit with him while I go grocery shopping. And the response to that is a police visit to your house?
no, it wasn't a police visit. It was a social worker visit. And
accompanied by a police officer who had clearly, from the evidence in the record, had a difficult relationship with Ms. Gallagher.
Well, evidently, Eileen Schoner was concerned about going to that house by herself, and she called.
And that may well be fair, but she brought a police officer and a police officer who had a history with Ms. Gallagher. For whatever reason, Ms. Gallagher may have provoked it, but there was a history.
Well,
it's like your position is that one unanswered phone call, which Ms. Gallagher contests was answered, in fact, answered by the lawyer, and one, is there any record evidence as to how long she knocked or how long she rang the bell? Was it because otherwise we take it in the light most favorable to the non-moving party, and that means it was like knock, knock, ring, 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 not like, oh, maybe she's in the shower or maybe she's, otherwise indisposed, and then they come in when they've seen him fine 2 days earlier.
And she knocked on the door. I think she also yelled, and she came down shortly thereafter.
Wasn't there also testimony or evidence that once they got inside, they could hear the shower upstairs?
I don't remember that.
It's in the police report.
Okay. But if you combine that with the concern of leaving Father LaPlante there, they were concerned. She went into the house to check on him. And I think that the issue.
I'm still back to, so is the position that a caregiver of a nonagenarian who undisputably cannot take care of himself, can't take a shower, can't ever sleep? Because that, I think that would be, I don't know, I think that the citizens of the Commonwealth might be shocked if that's the position for home care, that you can't sleep if you're just by yourself taking care of a nonagenarian. You can't take a shower, can't go to the bathroom, can't be in another room, seems to be what the position is of this officer and the wellness person.
Well, the position is that she looked in the door, she saw him lying there in somewhat distress, moaning. There was no answer from the caregiver.
Well, that's a dispute of fact that would make summary judgment not be able to be entered for your client. So that doesn't seem, if you want to preserve the summary judgment when you have, it seems like you need a different ground, and I'm not hearing what it was.
Well, the ground is that that's the only genuine issue of material fact. And there were other considerations, like I said, about the concern about him leaving, her leaving him with the stranger, not responding to the door, and they went in.
All right, so just one other question for you. You seem to argue that we should apply the law of community caretaking as it existed on the date in question. What's your best summary of what that law was, or what's your best case citation for that?
I would suggest, and when I stated that, I meant to say that the Superior Court did not consider a civil rights violation, so they never took into consideration whether there was a civil right violation, which I always say that there's always been. And I go back to the Canigula case, which talked about the fact that the only thing that the Supreme Court did was not extend the community caretaking exception from automobiles to houses, but that's all they did. And the concurrence always said that the exception to go into the house to protect somebody's life and safety were always applicable. So I would suggest that that's still available. And so in other words, where the Superior Court didn't take into consideration that there was no civil rights, there was no intimidation, coercion, or threats. But let's assume that there's genuine issues of material fact as to that. I would still suggest that there's an exception to the entry without a warrant requirement under that emergency aid exception. Or alternatively, as I said, that if there is a constitutional violation, that Officer Pompeo is still entitled to qualified immunity, because it was never clearly established that it was a violation of a person's constitutional rights to enter a house with his reasonable belief that the person inside is in need of care.
Do you agree that the officer was in uniform and had, and I don't know, but did she have a firearm with her?
Yeah, I'm sorry, Your Honor. Yes, I would stipulate that she was in uniform and therefore had a sidearm, yes.
All right. I think we'll have to leave it there. We will hear from Attorney Takahashi for Cape and Islands Elder Services.
Good morning, Your Honors. Yes, Dion Takahashi for Ms. Schooner and Elder Services. I wanted to address just a couple of the issues that were raised here a few moments ago. The first, I just wanted to point out again that this needs to be an objectively reasonable standard. So my brother, Attorney Hessen, went to great lengths to talk about how she felt like this was a Gestapo raid. She felt like she was under lockdown and her home had been commandeered. But when looking at the specific actions that she alleges Ms. Schooner took, no objectionably reasonable person would find those to be threatening, intimidating, or coercive. And I just point to several of the facts that Ms. Schooner allegedly said it will go easier on you if you talk. She requested the healthcare proxy and the power of attorney paperwork. She allegedly told Ms. Gallagher to take a seat. Ms. Gallagher has testified that.
Is your position then that elder care services can go into someone's house if they don't return one phone call and they don't answer one knock? They can just go into any house in the Commonwealth and demand their papers?
Well, they can make an unannounced visit. She had made efforts to
Right, but they
contact.
They entered
Yes.
without consent.
Well, I would say that this was a permissible entry. I believe it was under Strom and based on Justice Kavanaugh's concurring
but
opinion.
it's permissible. They saw him perfectly well eating his Burger King 2 days earlier, and then, at least based on interpreting the record in the light most favorable to the plaintiff, there was one phone call that was returned, and then they went to the door and knocked and called out, and then they could enter. That's, as a matter of law, the position of your agency and your client is that that's when you can go into any home in the Commonwealth on that basis to check on someone.
Well, herein lies the problem, is that the plaintiffs tried to lump together Ms. Schurner's actions and Officer Pompeo's actions just because they arrived together and were involved in this incident. I think Officer Pompeo did make a permissible entry under Strom and Cunningham and this court's opinion in Lindsay in 2009, which I think would have been controlling at the time of these events. But to look at Officer Pompeo's actions and then say that Ms. Schurner then, created all these, the trespass and the illegal seizure and whatnot. I mean, you can't just say that just by guilt by association that she was there at the time. So if all these things were happening and this is how the plaintiff felt, that it was Ms. Schurner's responsibility as well. Nor do I think that you can.
Excuse me, but it's a little more than that. Officer Pompeo is there because he's been invited. She's been invited by the worker. So
right,
why aren't their actions attributable to one another? That's what troubles me about this case.
So I think there's a disconnect. That Officer Pompeo wasn't there on doing her own investigation. So if she had seen Father LaPlante 2 days before and seen that he was okay, I mean, she's not there for her investigation. She's there now escorting Ms. Schurner, who was from an outside agency, unfamiliar with the plaintiff and Mr. LaPlante, and statutorily required to investigate this complaint.
That's my point, is that Officer Pompeo is invited by your client to be present and to act.
But I don't think then that my client, Officer Pompeo's actions, which again, I support my brother's argument that those were proper, but I don't think her actions, if improper, can be imputed to my client just because she is the one who requested the police assistance.
As a matter of law or as a matter of fact?
As a matter of policy. I mean, I think as a matter of law, Ms. Schurner should be responsible for what she did, asking for documents, which Ms. Gallagher says the entire time Ms. Schurner was in the kitchen looking at the documents. Now she's saying she was standing stolidly by and blocking her access to exercising her rights. And I mean, she never once says what she was compelled or deterred from doing. She doesn't say what rights she was prohibited physically from exercising.
Does Ms. Schurner ever say, oh, Officer Pompeo, no, we're not going to take him out of the house. We don't have authority to do that yet. She doesn't do that, does she?
I mean, the decision to take her out of the house or even to call the EMTs to come assess him wasn't Ms. Schurner's, but that wasn't her decision to begin with.
She doesn't oppose it, does she?
She did not. I mean,
all right. So could a jury
for her to be in a position of the same as the officer to be able to make the judgment call as to whether or not that was permissible or would be an improper seizure, she doesn't have the same sort of training on that as the officer would, and so certainly if she sees that the officer is making that call and feels it's proper, that I mean she's entitled to credit that as a reasonable determination by the officer.
Well,
is there a right to be let alone in your own home?
Of course. But again, I would refer to Cunningham and Lindsay that say that when there's a potential abuse or neglect or an elder reportedly in need, that those are circumstances justifying an entry. I mean, there's obviously some circumstances that a person's right to privacy in their home has to be pushed aside, unfortunately. And these were those circumstances.
But this is where, again, I'm stuck on the circular nature here. This woman calls and asks for help having someone sit with him for groceries. That results in an armed police officer talking into her walkie-talkie, showing up at this person's house and seeing that he's perfectly fine eating his Burger King. And then that officer reports this very thing that she just investigated to the elder people and then comes back to investigate it again. But if I'm missing something, I'd really like someone to tell me.
Well, the first time Officer Pompeo there, is my understanding, she was there with a different elder services agency,
Yes.
again, escorting them. And I think at that point, it wasn't the incident with the two individuals that she was investigating, but the fact that she learned of that. And certainly I don't want to step on Attorney Lewison's toes here, but the fact that she learned of that gave her reasonable concern for Ms. Gallagher's decision-making and caring for him, and that there may be some subsequent or underlying or correlating neglect. She reports that. That's what Ms. Scherner was there to investigate. She needs to look past just whether he was okay after that one incident. She now needs to go and look at the entire situation and see, is there neglect going on? Is Ms. Gallagher making improper, abusive, neglectful decisions, or is she properly caring for Father LaPlante? And so that's what
in the Supreme Court case, the hypothetical that Justice Kavanaugh offers is that the person is a regular attendee at church, but I suppose it could be a regular attendee at anything, didn't come to a meeting, and then the family member calls day and night and doesn't reach them. And then the family member says, would you please go check on this person? And then the police go. That seems like a lot more happened than happened here, where we have Officer Pompeo seeing him fine. And then there's one phone call and one knocking on the door and maybe calling out.
one of the differences here that makes this special is that this wasn't the usual elder services program that was familiar with Ms. Gallagher and Father LaPlante and would have normally responded. Because of some conflicts and some history between those parties, my client was called in outside, not familiar. So she's relying just on Officer Pompeo, who is familiar with this household, with this arrangement with Father LaPlante's 24-hour care needs. So she's basing it, I mean, she's going on the information she's receiving. And obviously the only way to confirm or refute that is to do her investigation, and that information is
Right,
that he
but
needs 24-hour care.
the whole issue that you and Attorney Lewison are relying on is an emergency. But if that was the case, then shouldn't they have come back on the 23rd or the 24th? But instead they waited 2 days. But then when it's not happening on their timetable, then it's an emergency and they get to go into a private citizen's home. Again, what am I missing?
I don't have it in front of me exactly when this was reported to Elder Services of Cape Cod and the Islands and referred to this outside agency. So as far as how quick the turnaround happened, I mean, I believe it was the day before on the 24th that she attempted to make these phone calls, attempted to establish and set up a meeting with Father LaPlante and was unable to. And then, the next morning she's contacting the police department and seeking an escort. And I mean, it wasn't an emergency for them to arrive. They were arriving for an unannounced visit for her to try to further her investigation. I mean, the emergency was, and they make a big disputed, try to make a big dispute of material fact on the visibility.
Was that they could see him on the couch, then you have a dispute of fact and there's no summary judgment.
But the interesting thing is all of the plaintiff's pictures, first of all, are from inside looking back towards the door. And secondly, one of them actually does.
That's a dispute of fact. Why don't we, I think, I'm reluctant to end this spirited conversation, but I'm mindful of the time.
Did you want to ask your question about what should they have gone to a judge? Like, you were asking, I think, about section 19 and 20.
I am holding that question, and it seems to me that there is a system provided for access in and obviously in extreme circumstances there are exigencies that will excuse that ordinary course. But why isn't the statutory framework the one that should apply in the ordinary course?
May I respond? Are you looking for a response?
Please.
Okay.
And then we will hear from Attorney Russo.
And I think in this situation, just because again we represent that it could be seen, and whether it was seen from the doorway or when Officer Pompeo sort of stepped in and continued to try and announce and get a response, whether at that point he saw Father LaPlante. I mean, then there was an immediate, we have an unresponsive gentleman whose caretaker be located, and we're going to step
And why
in
is
and
that
speak.
not a question of disputed fact? Because
I
we have
don't-
two rather sharply divergent descriptions of the circumstances that were visible from outside the home upon arrival.
Well, I think even if you credit Ms. Gallagher, and again, she could have easily shown us
Are we
pictures
required to do so on
establish
summary
that.
judgment?
Right. So if you credit her that they couldn't see from outside the door, they wouldn't have been able to have a view of Father LaPlante, then you have to say, well, look at the other circumstances. We're concerned that he's being neglected. We know that the plaintiff is home. There's a car here. Nobody's answering the door. He can't. So, is she in distress? Is she being neglectful? Is she, we don't have a caretaker to come and assure
So
us.
your suggestion is that on that undisputed record, setting aside the version offered by the plaintiff, on that undisputed record, we are within the extreme circumstances that justify taking outside of the statutory framework to go in and get a court order.
I think it justified their exigency and not seeking a further delay, because in the event that this was accredited and a finding of neglect, that Father LaPlante was in danger at that time.
I think we have your position. Okay, Attorney Russo.
Thank you.
Thank you, Your Honor, and may it please the court. South Shore Hospital asks that this court affirm the Barnstable Superior Court's finding of summary judgment as to plaintiff's false imprisonment and battery claims. I'll first address the false imprisonment claim in stating that there's no evidence that Father LaPlante was confined at South Shore Hospital. When he arrived at the emergency room.
Counsel, I'm confused about that, because everybody seems to agree, or at least if we credit the plaintiff, which we're required to do, she says she just put him in a wheelchair and wheeled him down the hallway, and she was yelled at and ordered to take him back to his room. So why does that not in and of itself result in a dispute of fact?
Well, Ms. Gallagher herself actually stated at her deposition that she was not trying to remove him from the hospital when she did that. She was simply trying to show the nursing staff and the providers that she was able to move him on her own.
Right, but if the question is, was she permitted to remove him from the hospital? She wasn't even permitted to remove him from his room.
Father LaPlante was permitted to get out of bed, and as soon as
couldn't get out of bed by himself. He could only get out with help, right?
Right, and he was permitted to do that. And as soon as
she tried to remove him from his room, she was told that she was not permitted to do that, right?
That is correct, but she did not try to remove him from the hospital. And that seems to be the crux of the plaintiff's argument here, is that he was confined to the hospital. And when he arrived, there was a workup done. Ms. Gallagher herself voiced medical concerns that Father LaPlante might be suffering from nystagmus or otitis. There was a workup done, 5 consults were ordered, and as soon as those consults were done and the investigation in the community as to Father LaPlante's guardianship and the protective order was denied, the hospital worked with Ms. Gallagher in order to create a safe discharge plan, and he was discharged.
Right, but isn't that the issue, that he was in fact medically dischargeable prior to Monday and the hospital did not discharge him?
Yes, however, under the Joint Commission regulations and the Emergency Medical Treatment and Active Labor Act, the EMTALA statute, the hospital was not, when there's a concern, elder abuse and neglect, such as in this case, there's an active investigation going on in the community, the hospital is permitted to protect that patient from any abuse, neglect, or harm while under their care. And
okay, so then I'm confused. Was your position, because you seem to now be saying she was not free to take him from the hospital, albeit you have a justification, but which one is it? Was she permitted to take him from the hospital before Monday or not?
She was permitted to take him from the hospital as soon as there was a safe discharge plan in place.
So not on Friday, not on Saturday, and not on Sunday?
No, because up until Friday and Saturday, the 5 consults, which Ms. Gallagher agreed to, had not been completed yet. And on Saturday, there was still an ongoing investigation in the community to potentially change his guardianship. And under the Joint Commission regulations, South Shore Hospital has a duty.
So she wasn't free to take him on Saturday?
No, not according to the Joint Commission regulations and the statute. And because I believe on that day is when he was medically cleared for discharge.
So just to make it clear, what you're saying is that that she was not free to take him but that continued detention was justified by the applicable regulations.
Correct. The confinement was justified for medical necessity, even if this court finds that he was confined. It was justified under the.
I'd like to walk through that a little more carefully. First of all, was there ever a written consent to care from his medical proxy, Ms. Gallagher?
There was not. There was not one that was completed.
On what basis did they begin to treat him? Were they authorized to begin to treat him?
Under the EMTALA statute, when a patient such as this one arrives in the hospital has a duty to ensure that they can stabilize the patient and there is not an active medical emergency ongoing.
Let's go through those step by step. First, starting with the Joint Commission. The Joint Commission performance standard says the hospital determines how it will protect the patient from abuse, neglect, exploitation, and abuse that could occur while the patient is receiving care, treatment, and services. I trust that's what you're relying on. But it says later on that there are written policies and procedures, and I believe the hospital is also allowed to take into account a refusal of treatment, correct?
They can take that into account, but when there's a situation such as this one, where there's an active investigation in the community as to this patient's guardianship and care, the hospital is under an obligation not to release that patient into a potentially similarly dangerous situation.
And for that, are you relying on the joint accreditation standard, which is, by the way, an accreditation standard for the hospital? It does not necessarily, it's something we can look to. I don't know, it governs the hospital's behavior. I don't know if it governs our decision making. That's a separate issue. We'll have to figure that out. But are you relying on the statute or the CFR for the notion that the hospital is then authorized to hold the patient against the wishes of the healthcare proxy? And if so, what specific provision of the statute or the CFR are you relying on?
I would look to CFR section 482.43, and that the hospital must have an effective discharge plan in place for this patient before they can release him once they're under the care.
I get that, but that doesn't get us to admitting him. I mean, once admitted, I understand, but what I'm struggling with in this case is by what authority the hospital admitted him. And there may be something there. I'm just looking for your help.
Ms. Gallagher herself voiced medical concerns that Father LaPlante might be suffering from.
But she never authorized treatment.
Did anyone ever ask her to authorize treatment? Is there proof in the record that someone did?
There was a consent provided, and there's a signature that says patient is unable to sign for himself.
Right. And so then it's sort of hard to say that she agrees when she's so disruptive that you remove her and then she stands outside with a picket sign.
That's correct. But again, when Ms. Gallagher she was permitted to return them to the hospital. And when she did not object to the 5 consults being ordered in order to assess Father LaPlante and make sure there was no medical emergency.
Did she consent to them?
She didn't object. She gave her implied consent because she did object to other sort of treatments. She objected to the administration of psychotropic drugs. She objected to a pneumonia vaccine. She objected to the use of a straight catheter. And every time she made her objections known, the hospital did comply. It was only when she didn't make her objections known that the hospital went on doing their standard medical practice and procedures.
Her testimony was that she was trying to get him out of there. And I don't know if you can do implied consent as a matter of law or whether that's a question of fact. I think that's just to let you know that's a concern.
I think we're going to have to leave it there as well. There are lots and lots of questions in this case, and we will sort them out. Thank you all for your presentation. The case is
Live and recording.
That brings us to the final case on our hearing list today, case number 2020P 1217, Lisa M. Jones versus Andrew Jones. This case is partially impounded. I'll remind counsel to refrain from unnecessary reference to any kind of material that is the subject of that impoundment order. We are streaming to the public on YouTube, and this case, as are all of our cases, open to the public as a result. I will also remind the viewers, as I've just reminded counsel, that we are using separate screens for the content, for the briefs and other the appendices, the other case materials we have for this case. And so when we as members of the panel look to the side to consult those materials, we are doing so for that purpose, not to divert our attention to matters other than the hearing before us. With that background, Mr. Novich, I will invite you to begin your presentation.
Thank you, Your Honor. Good morning, Mr. Chief Justice and Associate Justices Sullivan and Henry. My name is Richard Novich. I represent the appellant, Lisa Jones, and with me, although you can't see them in the conference room today, are attorneys Gary Todd and my colleague Dea Coca. Before I begin, I need to correct a misstatement that I made in my brief. On page 46 of our brief, I cited to the Williams decision that was decided by a panel of this court in 2015 for the proposition that bonuses were then decided broadly, or the definition was broadly made, and it was done so after, strike that, before the underlying agreement here had been signed. As I'm certain all three of you know, that was a misstatement. The Williams decision was in fact decided in 2015, not 2005. And it was decided 10 years after the agreement here was decided. So for that, I apologize. It was an oversight on my part, and I wanted to call that to your attention. I know you've all read the briefs, probably many times, so I will do my best not to regurgitate many matters that are already set forth in the briefs. In summary, from our perspective, this case is about two things: the propriety of the trial court's decision on cross complaints for modification, and whether the phrase "any manner of bonus paid" in the parties' separation agreement captures income father received from the subsequent exercise of stock options and receipt of preferred shares he received after the divorce. As to the first issue, in addition to what I would suggest is a clear error of judgment in ignoring my client's complaint for modification, the decision not to retroactively modify child support while simultaneously retroactively terminating alimony was both inequitable and, I suggest, an abuse of discretion. In support of that conclusion, the trial court judge made two critical findings. The first, he relied upon the fact, in his view, that the support that had been paid from and after the date on which alimony was terminated, April 2014 and forward, that the amount of support that Mr. Jones was paying was, quote, adequate. The second critical finding that I suggest is clearly erroneous and unsupported by the record that he made was that it would be, quote, unjust to Mr. Jones to award any retroactive child support. I'm going to focus on just those two facts for a moment. There are several problems.
But counsel, just, are you saying that we should disregard all of the factual findings that you listed out in footnote 19 of your brief?
Off the top of my head, I don't recall what footnote 19 said in the brief, but
it lists like several lines by number of factual findings.
Bear with me just one moment, Your Honor. Let me make sure that
It's pages 24 to 25.
You said footnote 19, Your Honor?
I think it was footnote 19.
The detailed, the specific findings that identify just by number?
Yes.
So those findings in particular, from my perspective, based upon, there are a couple of decisions that I cite in the brief, those quote findings that the trial court made were, in my view, simply recitations of testimony and not findings. They were regurgitations of what exhibits or documents said. And in my view, again, based upon a couple of decisions, I think of this court, that those are not proper findings and may properly be disregarded. The two findings that I'm
May we also, though, do we not have some latitude to determine that this may be a matter of draftsmanship and that the judge impliedly credited?
Of course, Your Honor, that's without a doubt. I think in this instance, it would be difficult for the court to draw any meaningful conclusions from the testimony that the judge recited. And I'll come back to a couple of those by way of example in a minute. The first one that comes to mind is, and I forget the number of the particular finding, but the trial court judge made findings as to the station or the lifestyle that the parties enjoyed during the marriage. On one finding, he explained that my client testified that the lifestyle of the marriage was upper income. In the very next finding, he said that Mr. Jones testified that the lifestyle of the marriage was middle income, and he never rectified the two. So I would suggest that it's impossible to discern a specific finding as to what that marital lifestyle was, because there was no ultimate conclusion that he drew from them. Getting back to the two findings that I say were clearly erroneous that undermined the underlying modification judgment and the trial court's refusal to make child support retroactive, it's important to note that the underlying decision retroactively terminated alimony for 5 years. And during that 5-year window from April 2014 to May of 2019, the decision wiped away the vast majority, 64% of the total support that Mr. Jones was required to pay. The alimony that the court retroactively terminated was $31,000 some odd dollars per year. As a result of the modification judgment, that evaporated, leaving Mr. Jones a base amount of support to pay of a maximum of $17,000 and change. I'm going to ask you to try to keep those numbers in mind because they're very important and significant from my perspective here.
So if I could just clarify, because one of the difficulties I had reading the briefs in this was the math, and I thank you for trying to clarify it because at times you were looking at there's weekly discussions and annual discussions, but am I correct that you are now using the same numbers as were used in the husband's brief, the 31 and change and the 17 and change plus the 10 for college?
Yes, I am, Your Honor. And
okay, great.
I'll do my best to try to synthesize that for you. And I would like, while we're on the topic, and I know, Mr. Chief Justice, you explained that there were other materials that you'd be consulting with while I'm giving my presentation. And I would ask the three of you to please take a look at Record Appendix 3, page 31. And I hope, Your Honor, Justice Sullivan, that what I'm about to say will put this into perspective in a clear and concise fashion.
All right.
And add some context to why we say and we believe that the underlying decision not to make child support retroactive was an abuse of discretion.
Just before you do that, can you give me the page number again?
Certainly, Your Honor. It's Record Appendix 3, Roman numeral 3, yep. And page 31. Okay. At the bottom of that page, there also should be a number 25, just so that we're all
right. Got it.
Right. So and before we get there, I want to ask you one other question because I'm just afraid I'll forget to ask it.
I hope I answer.
Your footnote 16, in which you do the running year tallies of income. This is at page 22 of your brief.
Yes,
and then you rely on an 8-year average of $680,821.
Yes, Your Honor.
Do those numbers include both liquidated options as well as salary?
Yes, Your Honor.
Okay, thank you. Thank you for your patience with me. And now we'll go back to your record appendix, page 31.
Thank you all. So if we look at page 31, and I will tell you that this is a one page from Mr. Jones's proposed findings that he filed with the trial court at the conclusion of the trial. Typically, I overlook these things in preparing appellate briefs because they really don't add much weight in my view. But in prepping for today's argument, I was reminded of this document, which I think is very significant to capture the context, and to show how the failure to make child support retroactive was an abuse of discretion. If we look at the left-hand side of this page, Mr. Jones explains in his view, taking his numbers at face value, his view for each of these years, and I'd like you to focus please on the years 2014 forward. And the reason for that is that was the year that alimony was terminated. So from that year forward, using the left-hand column of his own proposed findings, in 2014, he believes applying the guidelines, he should have paid my client base child support of $31,096. 2015, it's a little higher. 2016, it's a little higher, and so on and so forth. During those 3 years alone, again, using his numbers and taking them at face value, and I would say that these numbers are predicated upon only two things according to his math, and that's all set forth on this page. It's predicated only on the party's base salaries and bonuses. That's it. It excludes any income from stock options, and excludes any income from any other sources. By his admission, if I read this correctly, by his admission, during those 3 years, he should have paid a grand total of $97,812. And I arrived at that number, Your Honor, Justice Sullivan, simply by adding up the numbers in the column 2014, 15, and 16. Those 3 years, the amount of child support he should have paid on an annual basis totaled $97,812. Why is that important? It's important because during those years, as a result of alimony being terminated, the only support that Mr. Jones paid for each of those years was child support in the amount of $17,000 some odd dollars. So what he actually paid, if we added up the 3 years that he paid, $17,000 over a 3-year span, he paid $52,000 in child support, when by his admission, he should have paid over $97,000. A deficiency for just those 3 years of over $45,000. Again, these are his numbers. Of course, the trial court judgment found that Mr. Jones should pay a higher amount of child support. $838 was the amount that the trial court judge found that Mr. Jones should pay on a prospective basis, not retroactive, but on a prospective basis. On an annual basis, Justice Sullivan, the total amount of child support that the court found was required on an annual basis was $43,000 a year. So if we compare what he did pay versus what the judge found he should have paid, there's a huge difference. And the failure to make
if I could stop you for a moment, because it's a little, it's quite difficult, because since this argument wasn't made in the briefs, it's quite difficult to both listen to you and read at the same time. So I just want to ask you a couple of foundational questions.
Of course.
One is the support paid number there and the guideline amount number. Are those numbers only child support or the combined child support and alimony?
Excellent question, Your Honor. On the left-hand side of the page are only what he believes child support should have been paid. The column entitled support paid, and he references a footnote, you'll see a footnote 22. That's what he paid, which includes the alimony that was retroactively terminated. So comparing apples to apples, if you delete from the column support paid, if you delete from that column the $31,200 annually that the trial court judge retroactively wiped out, there is no question that you should come to the conclusion the amount of child support that was paid was deficient.
Did the wife submit proposed findings and rulings?
Not to my knowledge, Your Honor, and as I was not trial counsel, but as I read over the record appendix and the transcripts, it appears to me that Judge Phelan, the trial court judge, did not solicit proposed findings and conclusions at the end of the case.
And were these findings and conclusions that are in this record appendix, were they submitted as an exhibit at trial?
I can't tell you that, Your Honor. All I can say is that when I was compiling the record appendix, that this was a document that my sister wished to include, and I didn't object.
Okay. Then when it's her turn, if this is in here by agreement, there's no dispute that this was before the judge.
I believe that to be true, Your Honor, but I have no issue with certainly my sister correcting me if I'm mistaken. So for these
So,
reasons,
but let me just ask you, so the husband argues that based on the durational alimony limits, his alimony obligation was limited to 69.6 months or 60% of the length of the marriage.
Yes, Your Honor.
What do you say to that?
So what we've said in the brief is that my client takes no issue with the termination of alimony. What we do take issue with is the retroactive termination of it and the lack of any findings to justify the repayment or the repayment term that the court imposed under the modification judgment.
Was that raised below? Was there any claim of inability to pay raised in the trial court?
I specifically, Your Honor, I don't recall, but I can tell you that a 59E motion was filed at the conclusion of the case, and the trial court judge denied that as well. The 59E motion is contained within the record appendix. And I'm happy to try to find that for Your Honor and submit a supplemental letter if you wish, but off the top of my head, I just don't recall that.
All right, I'd like to know, your brief starts out with an argument that the wife's request for modification was ignored. Are you withdrawing that argument?
No, I'm not, Your Honor. I recognize I have 15 minutes of time, and I'm simply trying to highlight a few of the points in the brief.
All right, and we haven't even reached the bonus.
We haven't reached the bonus, which I see that my time is up. I'm happy to address that if Your Honors will give me some additional time, but I recognize that I may have talked too much about one topic and not the other. So,
Chief, may I just ask a couple of brief questions, and I'll make them
Briefly, yes, please. I know you'll be brief.
I just want to sort out the analytical steps. Would you agree that the first question is whether or not the options should be treated as a bonus? And if so, whether the cash derived from the surrender of the options should be divided?
No, the argument that we're making, Your Honor, let me try to recapture that if I could. The position is that, and I think it's consistent with the definition of income under the guidelines and this court's decision in the 2016 reported decision of Hogan versus Hogan. The argument that we're making is under the language used by the parties in the agreement, the any manner of bonus paid. The argument is that the earnings received by Mr. Jones from his exercise of stock options and preferred shares that were received by him after the divorce. So these were not marital assets.
Yeah, I think I want to shorten this up because I promised the chief will be short. I understand that argument, but it's a two-step argument. Do the options themselves not have to be first characterized as bonus income?
I believe that they do need to be first characterized as bonus.
All right. And then if they're characterized as bonus income, once they're exercised, then the 31%. If they're a bonus, then the 31% would go to the wife.
I believe that's correct, Your Honor. Yes.
All right. Thank you.
Thank you. And if my time is up, my time is up. Thank you very much for the opportunity. And I guess that's all I have.
Okay, thank you. Attorney Stone Tureski.
Thank you very much, Chief Justice Green. May it please the court. My name is Gail Stone Tureski, and together with Attorney Calabro and Attorney Judith McKinnon, who's not on record, I do represent Andrew Jones. Unfortunately, the facts of this case that we want to point out to you is that this was a marriage of 9 years. They've been in litigation for 12 years after their 9-year marriage. This is the second time we've been here. I think Justice Green, we were here when you had heard one appeal before. Mrs. Jones.
I don't remember all of these cases, but I remember this one.
I don't know whether that's good or bad, but thank you.
You've got limited time, so go straight to your argument.
I will, Your Honor. Let me just talk about when Mr. Jones didn't exercise those options. There was a change of control. They were exercised for him. He had no control over that. My brother raises issues in terms of a chart. That chart was not evidence. It was presented after the trial. It was presented as part of our findings. It was not, and one of the issues I want to make sure this court understands, I believe my brother is making a new argument with regards to that chart that never appeared in his brief. And I would ask that any argument regarding that particular chart not be included in your decision-making process. That's, I believe, under Rule 16, that if he didn't raise it in his brief, that it should not be able to be raised at trial.
Well, let me go back though. I want to understand because what we have before us, I mean, obviously we remanded back in 2015 for further review and assessment of the status of the stock options under the bonus clause. But separate and apart from that was an underlying request for modification based on a change in material change in circumstances. And it seems to me that that brought before the judge the overall question, whether it was whether the stock options were part of that or not, the question of whether a change in circumstances warranted a change in either child support or alimony or both. How do you respond to the arguments, before we get to the bonus question, how do you respond to the arguments that he makes in his brief on behalf of her about the justification for an increase in child support?
Well, increase in child support, it would have been disguised alimony. The judge made a finding that very clear and supported in his rationale that the wife produced no evidence that she was in need of alimony. He found that—
Whoa. Before you go to saying that it was disguised alimony, let's just keep it on the framework where it was requested and engaged. On the question of child support, I take it your argument is that there was no justification for an adjustment to child support, and if so, why?
Your Honor, under Brooks versus Payer and Smith versus Edelman, Mrs. Jones testified that the children's needs were being met. The judge found her, not credible on many circumstances, didn't find her credible that she didn't disclose the right amount of alimony. In over many years, she never told the court, Mr. Jones, or anybody that she was back to work. For many of the years that we're talking about, her income wasn't included in any calculation. She failed to disclose that. The Judge Ordonez found her not to be credible in one of the appeals that had come up before you.
That's not something that Judge Phelan considers, though, right?
He did.
You wipe the slate clean when there's a new trial, right?
No, but I think what he did, and what I'm trying to say to the court, is that the judge found that Mr. Jones had paid an appropriate amount of support. He had paid $17,000 a year. He had paid $31,000 in alimony. He had paid $10,000 in monies paid to a college fund. He had paid half of extracurricular activities. He had, during the time period that we're talking about, he had paid half of uninsured medicals. He had paid for tutoring. He found that the needs of the children were all met. He said that the children didn't want for anything. Mother even testified that the children were going to Red Sox games. There wasn't a discrepancy in the households that they lived in. The children were getting—
But wasn't there also testimony that the wife was doing some of that by spending more money than was coming in?
No, Your Honor. I think the judge found that many of her expenses were inflated. She had down $539 worth of expenses that were geared towards supplies to the house. He felt that she wasn't credible in terms of what they're needing. I think he made detailed findings that he didn't believe that the children's needs were a problem. In fact, he wrote down, she admitted they went horseback riding, Red Sox tickets. She purchased expensive cars for the children. They went on vacation. The judge never found that there was any disparities in the household. In fact, I'm quoting what the judge said here.
So the husband argues, though, that the trial court found the husband's historic support to have been adequate to meet the children's wants and needs, but then it wiped away the primary component of that support by wiping out the alimony and making her, not only did he made her pay it back.
Your Honor, we believe the judge was correct in finding that she had had a self-inflicted wound, so to speak, on the private school. Nobody told her to enroll those children in private school. She did that without the consent of the husband. And because that consent wasn't there, she violated that clear order, and that she spent money that she didn't need to spend. She wasn't had any reason to involve those children in school without his position and without his knowledge, that her expenses were inflated, that he made a finding that the children were adequately supported. There was no evidence, quote, there was no children, the court has not heard any evidence that the children were not adequately supported or that their needs or even wants were not met because of the amount of the child support that husband paid. This was after hearing 5 witnesses, 114 exhibits, 4 days of trial, he made correct findings that were not it was not an abuse of discretion. What he found was
Counsel, the 2009 support order was made, was it not, and correct me if I'm wrong, at a time when the wife had not been reemployed. She was reemployed in 2010, was she not?
In fact, Your Honor,
and at that point, she starts earning a 6-figure salary. Does that factor into the child support analysis?
Absolutely. She failed to disclose it. She went from a zero income to earning a 6-figure. That money that she earned wasn't factored in. If you factor that in, the judge was
wait a minute,
correct.
she could not have factored in income in 2010 and 2009.
No, but for most of the years that she's asking the court, she was working, and that her income was not being factored in at all.
Are you saying that she failed to disclose her new job to her ex-husband?
Yes.
Okay.
Yes, absolutely.
So if you ran the guidelines, and running the guidelines is difficult in this situation because there's income over $250,000. But if you ran the guidelines, where does the support number come out?
We ran the guideline, Your Honor, and we came out, the guideline should have been $550. The judge awarded her $838. We had asked that,
So where do these, I know you don't want us to talk about it, but where do the numbers come from in the proposed findings then?
We took his income, recalculated each year the guideline. We stopped the guideline and capped it at only bringing in $250,000 on the first $250,000 that came in to the household. The judge actually ran a full guideline, uncapped, on all their bases. So he actually increased the child support almost $300 more than we thought it should have been.
I'm talking about the number in the proposed findings and rulings that counsel has directed us to on page 31 of the record appendix. That seems to be a little different than the 550.
I think what we tried to do is to run each year, because at some point the guidelines had changed. And so we tried to run the guidelines when the appropriate ones were in effect. And we did our best to try to show the court what to do. Our proposed findings requested 550. And we did that based, again, I'm repeating myself, but based on the fact that there should be, like a circuit breaker, to the extent that you only run the guidelines in the first 250 coming into the household. We believe that's not what the judge did. He clearly considered above that income, and that's how he arrived at the 838. There was no.
I'm sorry, but we're running out of time already, and we haven't talked about bonuses again. Why would retroactive child support be unjust then?
It wouldn't be unjust to the father because he supported these children and their needs were all met. At some point, versus Brooks versus Payer or Smith versus Edelman, it gets to be a disguised alimony amount. There was no evidence presented.
Let's not talk about disguised alimony. The children's needs are met. Do we take into account her earnings when we look at the justness or unjustness of retroactive child support?
We should, but based on that chart that we did, we thought the husband had overpaid father had overpaid almost $245,000 on our chart. And I believe, Your Honor, that it's hard not to look at child support above the guidelines or the needs of the children if they're being met. There's no reason to just transfer wealth from one party to another if their needs are being met. The judge went through a very detailed analysis that the mother put forth no evidence that the needs of the children were not being met. She claimed, she bought cars for the children. She bought expensive prom dresses. It was discretionary on this judge, Your Honors. After a certain amount of money.
If I could, because we spent a lot of time on this, I would like to ask you about the bonus a little bit.
Sure.
There's two agreements here. One is the agreement between the parties that references the word bonus. And then there are the agreements between the husband and his employer and how those terms are characterized. There was a lot of evidence about the intent of the about the negotiations that occurred between the parties to the divorce. But there was some objection to the relevance of the understanding as between the husband and his employer. Do you have any case law that says that the negotiating history between the husband and his employer and the understanding between the husband and the employer may be used to inform the probate and family court judge's decision as to what bonus means in the separation agreement?
Unfortunately, Your Honor, between Nolte and Williams in this case, you have identified that the world of executive compensation is very complex, and that you can't just go under a dictionary definition, and sometimes even what you see on paper may not be the correct intent of the parties. And we thought about that, Your Honor. It's a very good question.
By what authority do we look to the husband's negotiations with a third party?
Right. I think you have to
take. Is it because we look to industry practice to inform the meaning of the word, or the marketplace?
Right.
Or it's not going to, executive compensation is not a matter of common understanding.
Correct. So, Your Honor, what we've decided, and that's why we put two witnesses on, and we put two experts on. Mr. Tillman, the expert, said that this was.
Excuse me. I know what the expert said, but there was an objection to their testimony, was there not?
And it was denied.
And it was denied.
Yeah.
And what I'm asking you for is authority for the proposition that that was correctly denied, and a rationale for admitting that testimony.
Because of the complex nature of executive compensation, we thought it was appropriate for the judge to get an expert opinion, which was reasonably.
Why does that go to what the understanding of the parties were when they negotiated this?
It goes to both. It goes to the credibility of what Mr. Jones thought he was doing. We put forth 5 different drafts, and each draft, as your honors will have it, showed how in each draft it turned different. Mr. Jones, in fact, the judge found her not credible when she said, I don't understand stock options. She has an MBA. He didn't find her credible. Mr. Jones testified that there was no way he would have given her options. There were options at the time of the divorce. She could have asked for them. She could have asked for gross employment income under Wooters, very different. She didn't. She knew that there were stock options.
If the stock options are not treated as a bonus, how are they treated?
They are income to him, but it wasn't susceptible to anything under the statute. Her needs were being met. And I don't want to go back to the alimony piece, but I want to just concentrate on the bonus piece. Mr. Tillman testified and Mr. Anderson testified. Bonuses, and I think you've even confirmed this, in Greeley, if you're asking for a case, I think Greeley is more on point in this case, that bonuses, and I think I'm up, but let me just finish my thought. Bonuses are based on a performance metric. You would have gotten them anyway. an option is an equity ownership, an equity grant. Mr. Anderson, the CEO, testified that wasn't what he was given a bonus. This wasn't a performance metric because he didn't want Mr. Jones to get the money unless there was a change of control. If you had labeled it as bonus, it might have gotten to him when it shouldn't have. And
But
so
what do we
put
do with the fact that there seems to be plenty of documentation that at least one of these payments was a bonus, and that's what it was called to the other person who got it. And then there was some discussion, very carefully worded on your client's part, and then the language changed. So what do we do with that?
Mr. Anderson testified very credibly, and the judge made detailed findings and did not abuse his discretion that explained the difference. This was a younger person, wasn't that important in the realm of what Mr. Jones was doing. It wasn't the testimony that you heard. What you heard was they didn't give him enough equity ownership, and there was a change of control. They gave him some severance to true him up, but it was never intended as a bonus. The language in other employees was different. We were talking about a CFO. They didn't care enough about that younger, more inexperienced employee. And the reason Mr. Anderson's testimony is so important is that it supports Mr. Jones's testimony as to why he didn't believe that. One of the things that the court asked us to do is to look at what the parties had done after the divorce. Mr. Jones paid Mrs. Jones 31% every year of any cash bonus that he received. Mrs. Jones is asking you to redo it because she doesn't like the outcome of what this judge, after hearing 4 witnesses and assessing the credibility of all those witnesses, made clear and concise findings that were supported by a decision. If the abuse of discretion didn't show that there were reasonable alternatives or that it was clearly wrong, this court should affirm the lower court's decision. Deference should be given to the credibility of the witnesses that he heard. Mr. Tillman reported clearly, just supporting why Mr. Jones's intention was correct. It was reasonable. He understood that to be.
Stone Tereski, we are well over time. I think
Thank you very much.
There are a lot of moving parts in this case, but I think we're going to have to rely on your respective briefs for the issues and questions that we did not succeed in reaching during the conversation. With that, it will conclude the argument in this case. So the case is submitted, and it also concludes our session today.